I
Yes.
have to reach back Guwahati as early as possible. But since item number 12 is part heard, if it can be taken
We'll
up,
release it then.
no, let it be taken up. I have no problem. Immediately after the orders, before the other hearing matters, if it is taken up, then it is no problem.
All right.
Right.
All right. Then after item number
12,
12, after that,
after the orders, ma'am.
after the orders.
Lordship, may I, Lordship?
Hmm.
Lordship, I beg to mention item number 10, Lordship. It may be listed after 2 weeks, Lordship.
Okay. Item number 10, after 2 weeks.
Lordship.
Ma'am, Lordship,
Hmm.
I'm on behalf of petitioner.
Hmm.
I'm on behalf of petitioner.
With the consent of the other side.
Good. My Lordship,
You are for the respondent.
I'm for the state, Lordship.
State,
And,
state respondent, huh?
yes, Lordship.
L. Hage, Miss L. Hage, with the consent of the other side. Learned additional PP, Miss L. Hage, with the consent of the other side, has paid for adjournment. When do you want?
After 2 weeks, Lordship. My supply.
Ma'am, Lordship,
Hmm.
my Lordship, I beg to mention item number 14. This matter may be taken up after 3 weeks, my Lordship. I have taken consent from the petitioner.
Government advocate.
Yes.
Learned Government Miss K. Wangmo, with the consent of the other side, has prayed for adjournment. List the matter. What is
After
it?
3 weeks.
After 3 weeks.
Well, Lordship.
Hmm.
Lordship, I beg to mention item number 13, Lordship.
Hmm.
I'm for the respondent, Lordship.
Hmm.
Lordship, this matter may be fixed on 2nd December, Lordship.
On behalf of Learned Council, Mr.
B. Lona.
Huh?
B. Lona.
B. Learned Council, Miss B. Lona, on behalf of Learned Council, Mr. D. Panging, with the consent D. Panging, with the consent of the other side, has prayed for adjournment. List the matter when do you want?
2nd December.
On 2nd December.
Okay.
I beg to
Hmm.
My Lord, I beg to mention item number 6, my Lord.
Hmm.
This matter will be taken up after 2 weeks, my Lord.
After 2 weeks.
Yes, ma'am.
Learned, your petitioner in person?
No, my Lord. I'm for the respondent, my Lord. State respondent.
Okay. Learned Government Advocate?
Yes, my Lord.
Miss
T. Wangmo, my Lord.
T. Wangmo,
Wangmo.
with the consent of the other side,
Yes, ma'am.
has paid for adjournment. List the matter when do you want?
After 2 weeks, my Lord.
After 2 weeks.
Number 15.
May I praise the Lordship, my lord?
Yes,
I'm on
yes.
my lord, item number 15, my lord. Today I am
Hmm.
not keeping, today I am not keeping well, my lord. It is a matter has come for hearing. So Lordship may kindly
Okay.
fix the matter on 25th,
25th.
my lord.
Item
November.
number 15, anyone from the other side?
Yeah.
Learned Council, Mr. A.K. Pukasta, has prayed for adjournment. List the matter on
25th,
25th.
25th is holiday.
November?
25th.
November.
November is a holiday. 25th November is a holiday. So
Then 20
some other day?
26th,
It's a holiday here, over here.
26th,
In Itanagar. 26th,
26th.
yes.
Yes.
Yes, 26th.
item number 1.
Lordship,
Mhm.
I have taken step, Your Lordship. Last occasion, I was instructed to take such steps.
Everybody is present.
By the time for the respondent of 1 unit of India, madam.
Respondent number 1 is present, then respondent number
My lord, I am for 2, my lord.
2.
Yes.
So service report is awaited then. You have taken steps.
Yes, Your Lordship.
Okay. So 1 and 2, they are present, then rest 3 to 6, they are not present.
By name, my lord, the rest of the respondents have been implemented as implemented, my lord.
Hmm.
By name, my lord.
By name.
Actually, it has to be the authority of the NIT, my lord.
Hmm.
by name, by,
Mm.
they don't have the direct business with the state government.
Hmm.
So it has to be the authority of the NIT.
Hmm.
Anyway, as per their the
By name, they have.
by name, they have been written.
Let me check the office note.
No office notes.
No office note. Okay. Learned Counsel, Mr.
P. Wangpan, Your Lordship.
P. Wangpan
Yes.
is present for the petitioner. Learned Counsel DSGI, Mr. M. Kato is present for respondent number 1.
One.
Mr. Learned Counsel, Mr.
RH November.
R.H. Nabami.
Yes, ma'am. Nabam.
Nabam is
Yes.
present. Sorry, I forgot.
Yes.
Long time no see. I forgot your names.
NIG.
R.H. Nabam, senior advocate, no?
No, ma'am. Additional.
Additional double AG.
Double AG.
Double AG is present.
respondent number
R.H. Nabam is present for respondent number 2.
Yes.
Service report on respondent number 324, 3456. 3 to 6 is awaited. List after 2 weeks.
My lord, no issue.
Diploma.
Most of it.
Item number 2.
Marvelous, my lord. So, my lord, in this case,
Mm.
on the last occasion after hearing of the certain extent, it was concluded that the government has sought the time for instruction.
Mm.
So, in the next occasion, the instruction was not available. So, today, whether the instruction is available or not.
Here, today also I have not received the instruction also.
Mhm.
So may I pay lordship notice may be issued in
Okay.
Yes.
Do you want to proceed or can we dispose it?
lordship.
Do you want to proceed?
My lord, I have no objection. But since they are taking the time for, my lord,
Or can we dispose it
Instruction.
today itself?
Lordship,
You need some time.
only because instruction has not come.
Okay. Learned Counsel, Mr. C. Modi
remote.
is present for the petitioner. Learned Government Advocate, Mr.
As Tapin lordship.
S. Tapin
No.
has submitted for some time to obtain instructions. List the matter after 1 week, 2 weeks,
2 weeks. lord.
2 weeks.
Item number 3.
Lordship, on the last occasion, the government was supposed to take instruction law. Exactly, what is the instruction law?
My lord, the instruction is like this, my lord. My lord, preliminary inquiry is going on. Now, basically, my lord, is civil work, my lord.
Mm.
So civil work, my lord, this anti-crime bureau, my lord, they are not technically expert my lord, in civil work, my lord. So for assessment, my lord, they have asked the concerned deputy commissioner to constitute, my lord, a technical expert committee, my lord. So, my lord, perhaps, my lord, they are assessing. Once the assessment is done, my lord, it will be given to the this anti-corrupt bureau for further my lord, investigation, my lord. So that is the latest status, my lord.
Mm.
So it will take some more time, my lord.
To obtain instructions.
My lord. My lord, for assessment, my lord. So
Assessment, for
yeah,
assessment.
For assessment, my lord. Because it's a construction of work, my lord. So police department, they don't have technical expertise. So they have asked the concerned deputy commissioner to consider committee, my lord. My lord, the expert committee, so that they can assist, my lord, whether it was properly construction or done or not, the material quality is maintained or not, my lord. So that assessment, my lord, that report is, my lord, awaited, my lord.
This is in process of, for preliminary inquiry.
For preliminary inquiry, my lord,
Okay.
yes. Otherwise, my lord, the works are
Seeking
being done.
assistance from the expert.
Yes, my lord.
Okay,
The quality work, other work are being done, my lord.
okay.
The question is, my lord, quality work, my lord.
So on ground, nothing has been done, it appears.
No,
The allegation is.
the allegation is that, my lord,
Hmm.
but the work has been done. Now only, my lord, the quality work, the assessment, my lord,
Hmm.
whether it was done as per the DPR or not,
Okay,
my lord.
taking some more time.
Yes, my lord, for that.
At
this stage, Lordship,
My lord,
notice may be issued, Lordship. Let them file affidavit, Lordship, as per process. Since the matter is PI.
Filing affidavit from them.
Yes.
In that case,
Okay.
My lord, based on this, my lord, yes, we can file a affidavit, no issue, my lord.
notice can.
Hmm.
Sir, I am for the respondent number 4.
Hmm.
The respondent relief sought for is against the state respondent. Here, respondent number 7, Union of India is nothing to do with. Since the matter has already been registered before the ACB Thanagar, earlier it was SIC Vigilance. So therefore, investigation has to be after all by the officer in charge who carried out the investigation now. So therefore, the respondent number 7 is nothing to do with.
Yes, what do you say?
This is
In-
Papoma, Lordship. Since
Papoma.
money has been released by the Union of
Okay,
India.
okay.
Even
Papoma is
no,
required.
no relief.
No.
There is
No, no.
nothing.
Yes,
Funds have been released by you, I
Yes.
saw.
yes. There,
Relief
Re-
sought for
relief-
is against the other respondent.
yes,
In due course, we'll come to know if you are required or not.
yes.
After some, after a few dates, we'll get to know if
Yes.
your presence is required or not.
Yeah.
If I use the Periyar person also, it is against the best other respondent, not the severe.
But he insists that money is released by UI.
Yes.
Releasing all monies are being released by the Union of India.
Always,
But
yes.
then it is up to the state government how it has to be used for the such project work.
Yes, would you say?
And there is no the statement even that the Union of India is not monitoring once the amounts are.
Not at this initial stage, maybe later. Maybe later. Learned Counsel, Mr. T. Tapak is present for the petitioner. Learned DSGI, Mr. M. Kato is present. For
Respondent number
respondent
7.
number 7. Learned double AG, Mr. N. Angamino. And
RS Nabam.
RS Navam, my lord.
RS Nabam. Additional AG.
RS,
Nabam.
Navam, my lord, Navam.
very sorry,
For respondent number 1, my lord.
Additional AG. Additional AG.
double AG Arunachal Pradesh, Mr. RS Nabam is present for respondent number 1.
Respondent number 1, my lord.
Notices may be issued to the other respondents.
Yes.
List the matter after
After 4 weeks, my lord.
4 weeks.
4 weeks.
Item number 4.
May I please, Lordship?
Yes.
Lordship, this PL is file on challenging for a misappropriation of rupees 1 crore 98 lakhs in the name of tender.
Hmm.
Lordship, first of all, I would like to take to page number 26, my lord.
Hmm.
Page number 26 is press notice released for NIT, my lord.
Hmm.
May I just read out the operative portion, my lord? The Executive Engineer, Agency Division PWD, Agency AP, on behalf of Governor of Arunachal Pradesh, invites sealed item rate tender in form CPWD 8 for the following works from the registered contractor of APPWD in appropriate class domicile within the jurisdiction here in the my lord APPW Arunachal Pradesh Public Work Divisions, which has to be registered territorial jurisdiction of 28 Likhawali Assembly Constituency as per Arunachal Pradesh District Wage Entrepreneurs and Professional Rules and Arunachal Pradesh Extraordinary Gazette notification published on 13 April 2015, Gazette number so and so, will be opened on the same day at the same on the time so and so, Executive Engineer or his authorized representative in presence of the intending tenderers intended to be present So here in the, my lord, date, time has been given for submission of the tender documents, and opening of the tender document has been given. Amount is 1 crore 98 lakhs. So the name of work is given, my lord, in third column, my lord, name of work, providing up two numbers, superstructure component in already constructed abutment at the DG Nala in Jensi Saveret Road, span 45 meters and 15 meters under Lower Siang district. So accordingly, my lord, this respondent number 5, they have invited this tender notice, and respondent number 6 has participate in the tender process. So as per the terms and condition of the tender, that tender, the bidder should be registered in Arunachal Pradesh Public Work Department, and as per district-based entrepreneur, Arunachal Pradesh district-based entrepreneurs. So here in the case is that, my lord, very ab initio, the respondent number 6 is not registered within the Arunachal Pradesh Public Work Department.
Okay. Who is for respondent number 6?
6, my lord, 6 was, I think the honorable court has ex parte proceeding, because he was many times,
Absent.
despite of service, he was not appeared.
All right. See, he is not registered
Yes,
under
he-
the Arunachal Pradesh.
Arunachal Pradesh Public Work Department, he was not registered. He was registered, page number 31, my lord. He is registered in Assam Public Work Department.
Okay.
The respondent number 6, farm was registered under Assam Public Work Department in class 2, eligible to participate in that tender process. And despite of that, respondent authorities accepted the farm, and he was selected, and he was forwarding for acceptance letter, and on the same day, his tender was accepted by the authority. Respondent number 4 and 5. My lord, page number 31 is a registered certificate of the respondent number 6, my lord. Registration certificate, which is clearly mentioned down below, my lord, the box, it is in column, name of the contractor with address and registration number is given. So he was registered in Assam Public Work Department in class 2 category. So thereafter, my lord, they have, despite of this disqualified in the tender process, he was accepted as a qualified bidder in that tender process. So agreement was executed between the respondent, government respondent authorities and respondent number 6, my lord. That is page number 33, my lord. This agreement 32. Page number 32 to 33, agreement was executed. And thereafter, my lord, what happened? This petitioner, they have seeking RTI before the concerned authorities, and RTI document is furnished to the petitioners on dated.
You participated in the bid.
Yes, my lord.
Where-
No, my lord. I was not participate in the tender process
Oh,
because
PL,
yes, this is PL, my lord. Since I am the social worker of that particular Lower Siang division, and I have some posts in Arunachal Pradesh Contractor Welfare Association. In fact, I was not participate in that tender process, my lord. So the tender document
How you
was
are aggrieved?
my lord.
You were not a participant, you did not
My
participate.
lord, here in
How you are
the
aggrieved?
my lord, here in the agreed is that they have not properly executed the work. Work was accepted on 24 March 2021, my lord. And on the same month, the department has released the sum of rupees 1 crore to the contractor before execution of the work. And work was not properly executed, my lord. That was the contention of the petitioner, my lord, herein.
The contractor who participated are not before this court.
Sorry, my lord.
The contractor
Yes,
who participated in the bid tender
yes, my lord.
and who have not yet and not been selected are not before this court.
Not before this court.
Okay.
Despite several notice
They
was
are not
issued,
aggrieved. How you are aggrieved?
my lord, agree with that. I am being citizen of that particular area and particular district. So work has to be executed properly, my lord.
Yes, not
So
properly.
not
executed.
properly executed.
Have you filed complaint?
Yes, my lord, I have filed complaint before the executive engineer, respondent number 6, and also legal notice by issued to respondent number 6, my lord. So despite of that, they have
That means
not taken
work
any
has already
initiative.
been executed.
Work has not been properly executed. Before execution of the work, my lord, sum of rupees 1 crore has been released before execution of the work, my lord.
Okay, then it's a different case.
So work was not executed properly, and the sum of rupees after filing of this PL, my lord, rupees 98 lakhs was released. The honorable court has not given any interim relief. Because of that, they have released sum of rupees 98 crore. Yes, entire amount.
Yeah, now 98.
Earlier, my lord, before execution of the work, they have released 1 crore, and during pendency of this PL, they have released 98 lakhs.
Okay.
So here in the, my lord, page number 38, my lord, in RTI reply, lordship may come to page number 38. In last column, page number 38, box para number 17, my lord, page number 38, my lord. Just which I seeking information before the concerned authorities.
This
Just-
RTI reply.
Yes, my RTI reply. Just I read out, my lord. Information regarding any payment with details like amount, date of release payment, a copy of check, BC, bank draft, PFM, etc. till that, if any. The reply is in next right side, my lord.
Okay, this is RTI
Total expenditure, yes, my lord.
application.
Yes, my lord. RTI reply, my lord. Reply by the respondent number 6, my lord.
This is the RTI reply.
Yes, my lord. RTI
Page
reply.
38.
Page 38, my lord.
Okay.
So right side, my lord, they have replied the total expenditure incurred as on date is rupees 100 lakhs. That is 1 crore, my lord. Payment made toward government check. Copy of check is not available. Payment made during March 2023, my lord. Whereas, my lord, 24 March 2023, they have acceptance of the tender, my lord. And the agreement was made on 24 March 2023, my lord. So before execution of the work, they have released 1 crore, my lord. So that was, even then, the contractor has not properly executed the work. So thereafter, we have, my lord, served legal notice toward the respondent number 6, but respondent number 6 has never been replied to the legal notice, as well as they have
Legal notice demanding what?
my lord, demanded. It was demanded for the properly execution of the work, and as well as retender of that particular project, my
You
lord.
said that already executed. Now how it can be retendered?
My lord, since work was not been executed and amount has been disbursed to the respondent number 6, my lord,
See,
by respondent 5.
After the amount already dispersed,
Yes.
how it can be retendered?
My lord, if the honorable,
Why it is in PIL?
my lord, suppose they have taken the money without execution of the work. So in that circumstances, money has to be returned to the government, my lord, for retendering. Because they have, without execution of the work,
If they have not properly executed after accepting money, after release of the money, complaints would lie that properly not executed. Have you filed complaint?
complaint was made, my lord, complaint was
Okay,
made,
where
but
is the complaint?
complaint copy is not enclosed here with the
Okay,
petition.
why?
So despite the legal notice was served, so legal notice was not been replied. So thereafter, they have compelled to file this PIL, my lord. So if we go through the reply of the government respondent, my lord, it's page number 49. They have admitted that it was inadvertently acceptance the tender. Despite the respondent number 6 is not registered in APPWD, my lord. So they have,
No, you are aggrieved by the acceptance of the tender of the respondent number 6, or aggrieved by the non-execution of the work properly?
work has not been done properly, my lord.
Okay, you are aggrieved by that?
Yes, yes, we are
No
agreed
acceptance
because
of-
we are the citizen of that particular area, my lord. And as well as I
That
am
is why
being
I'm
so,
saying, if the work has not properly been executed,
yes.
then why you did not lodge complaint? Have you, if you have lodged complaint, why you did not annex?
Complaint has been launched, my lord, after complaint has been launched, they have not
Complaint
been
lodged before whom?
before respondent number 5, my lord, executive engineer, who is the executing agency in that particular project, my lord. So after non-responsive of the respondent number 5, then again this legal notice was served. But even then they have not made any reply to the legal notice, my lord. So the petitioner has compelled to file this
Why
PL,
is
my lord.
PIL? When you have not completed the process of complaint, and a complaint, if it is not attended, then it has to be criminal complaint if they are not performing well, or if they, after accepted the money or withdraw the money and not executed properly, and if you think that they have siphoned of the money without executing the work,
Yes, ma'am.
then it has to be a criminal complaint.
That,
It has to be
that,
investigated, inquired, isn't it?
after filing,
Why PIL? What we can do? What the court can do? What direction you are expecting from the court?
my lord, my prayer is in PL, my prayer is that if work has not been properly executed, so
Okay.
that amount has to be refunded to the government
How
exchequer.
that can be?
And
Then
then,
work was performed. Work executed. You said that work executed. It's only not properly done only.
work executed that was not properly done, my lord.
Hmm.
And then like one continues that before execution of the work, the 1 crore has been released and it was completely misused. That was nexus between
But
the
it is a
respondent number.
misuse with nexus, then criminal complaint only.
Exactly, my lord. That was not done from the part
Then-
of petitioner here in the PL. So now their continues that the work has been completed and during pendency of this PL, even we have praying for interim protection for not to release the remaining fund of that particular scheme project, my lord.
Just stated, no, they have released that 98 lakhs also.
Yes, my lord, they have already replied, my lord. India replied, or government respondent have already made reply that work has been completed, payment has been made. As per their reply, my lord.
So will this PIL can we proceed with this PIL? Everything is complete now?
That is the problem, my lord, since we have time and again seeking relief from the honorable court to interim relief, that till disposal of the writ petition at this PL, my lord. So that payment has not been released by the respondent number 5. But we didn't get relief from the honorable
So
court.
while submitting, what I could gather is that entire fund has been released.
As per
So
their,
your
as per their
doesn't
reply, madam.
lie now,
As per their reply, they have,
released. Okay.
they have
Let's hear
released.
them then. Then we'll come back to you, get back to you.
Yes, yes.
Let's hear it.
My lord, this PL has been filed, my lord, in wrong understanding of the tender conditions, my lord. Tender, for what purpose the tender was plotted, my lord. Now, it's a fallacy on the part of the petitioner, thinking that it's a construction. No, it was a supply material, my lord. It was not the construction, number one.
Supply matter.
Supply materials, my lord, not construction, my lord. That's a wrong submission. If your lordship see, my lord, NIT, my lord, page 226, my lord, press note.
Page 26, we have gone through it,
Yes, my lord.
but we have not noticed it's supply matter or construction.
It's a structure, my lord, providing two numbers of superstructure component in already constructed abandonments at so and so. So building was constructed, only the supply material was required, my lord. For that purpose, my lord, this NIT
Which,
uploaded.
which,
Page 26, my lord,
page 26, which part?
of the, my lord,
Name of
petition, my
work,
lord.
name of
Name of work, my lord.
Yes, yes.
Name of work, my lord. Down below, your lordship will find, my lord.
Providing two
Two-
superstructure components
Yes, my lord.
in already constructed abutments at DG.
DG Nala. So, Genci, Sevrite Road. So, my lord,
Okay.
it is just
These are already constructed.
constructed. Only supply material was required. That is number one. Now, my lord, when you say, my lord, PL, it's a public litigation, my lord. Now, the construction and completion of the project will not be a public interest, my lord. Now, the contractor who executed, my lord, may not have, my lord, district-based enterprise registration, my lord. My lord, he is a Arunachal contractor registered, my lord, under PWD department, my lord.
Assam Public Works Department.
Assam Public Work Department,
But
maybe.
from Arunachal Pradesh.
Maybe, my lord. Maybe, my lord. Suppose, my lord, that inadvertent has been caused, my lord. Will that, my lord, affect any way in the, my lord, construction or supply of the materials? They have not said in what manner the supply or construction, my lord, material is poor quality. It's just a, my lord, blanket, my allegation that construction is poor quality or supply poor quality. On what basis? There is no whisper on that. Now, another thing, my lord, when this PL was filed, you lordship may kindly see, my lord, that this was filed on 13/2/2024. Now, the affidavit filed by the department, this supply work was already completed on 27/3/2023, my lord, more than 1 year before, my lord. Now, on what basis my friend is saying, my lord, the construction or supply work is not completed, my lord? 1 year before, my lord.
20?
My lord, this was filed on, my lord, I'm sorry, my
2024 PIL.
12 January 2024.
Mm.
This present PL has been filed. And our contention is that the supply was completed on 27/3/2023, my lord.
Mm.
So almost a year, my lord. Year, my lord. Now, everything is completed, my lord.
Yes.
Now, only what I can understand, my lord, from the petitioner side, my lord. Sometimes he says, my lord, he participated. Sometimes he says, he did not participate. What be that as it may be, my lord. Now we have to see that is there any, my lord, effect to the public interest or not, my lord. Now he's saying, my lord, he's from that area, my lord. Now he's a social activist, my lord. I will not harp on that, what kind of social activist, my lord. But what is more important, my lord, the petitioner has failed to demonstrate anything, my lord, that the supply work or the construction is in poor quality, my lord. In what manner, my lord? It's just a general statement, my lord. What we can understand, my lord, either is a personal grace or, my lord, some sort of, my lord, publicity. That must be the intent of the petitioner for filing this present PL, my lord. Now, time and again, my lord, we have seen, my lord, getting up frivolous petition are being filed in the name of public interest litigation. My lord, when we say, my lord, making an allegation, my lord, it's a court of record. You must, my lord, substantiate with the contention when you are making an allegation that this is the poor quality, my lord. When you say, my lord, supply of material poor quality, on what basis? Either in company, my lord, making manufacturing defect, or, my lord, volume, my lord, or size. Nothing is there, my lord. If construction also, my lord, in what manner, my lord, the construction is poor quality, there is no whisper in this, my lord, public interest litigation. Now, keeping all this aside, my lord, when you say the technical, my lord, we have a Guwahati High Court rules, my lord, 2011 public interest, my lord, rules, my lord. Now, in this rule, my lord, rule 10 says, my lord, you must make a proper representation to the government, appropriate authority, my lord. Executive engineer is not the government or the appropriate authority. So, there is a, my lord, violation of, my lord, Guwahati High Court rules,
Page.
my lord, rule 10, my lord.
Rule 10, I know that page, I keep forgetting.
2011 Guwahati High Court public interest litigation rules.
Page number will be good enough.
Page number, I'm sorry. I remember the rule 10, my lord.
Okay.
Rule 10, my lord, there are a series, my lord. I think A to,
Yes.
yes, my lord. So, number one, my lord, no proper representation was submitted to the appropriate authority. Then, my lord, now, my lord, on what basis, my lord, is making the allegation, my lord? The source, my lord. Simply, my lord, adducing the, my lord, NIT, that will not suffice, my lord. When you are making my lord, allegation, the allegation must be, my lord, supported by the document. My lord, these are the technical expertise, my lord, expertise required, my lord. Now, petitioner, my lord, I don't think, my lord, he has any degree pertaining to, my lord, quality of, my lord, which material is, my lord, better quality, or which, my lord, construction is not up to that mark. My lord, I don't think he is competent to say anything about that, my lord. Now, as we have said, in the affidavit, my lord, paragraph 9, my lord, we have said, my lord. Now, this is also another wrong submission that without any execution or supply of material, we have, my lord, released the fund. That is also not correct, my lord.
Affidavit, which page?
My lord, page 5050, my lord, internal page, paragraph 9, my lord.
Para 9 of.
Yes, my lord. We have categorically denied, my lord, without any education of work, we have not released any amount, my lord. We have also said, my lord, now the private respondent 6 is a manufacturing, my lord. They have a manufacturing unit, my lord. If they have unit, my lord, the structure they can, my lord, manufacture with no time, my lord. So this was supplied on, my lord, 26/3/2023, my lord, and it was completed 27/3/2023.
Okay.
My lord, material was supplied on 26. So installation was completed on 27. It's a, my lord, installation materials, my lord, supply material. So, my lord, there is no any, my lord, siphoning of any pan or supply of any poor quality, my lord. It's just as I've said, my lord, maybe my lord, personal grade or for publicity, my lord. My lord, there is no any public interest, my lord, in this case, my lord. And this petition, my lord, based on that, my lord. Even the High Court rules are being not maintained, my lord. So it is a piteous case to be dismissed, my lord.
All right.
So you are not seeking setting aside of the work order granted to the
Private respondent.
private respondent, isn't it?
There is no
My lord,
such
in
case.
my
Not your
prayer,
case?
my lord, in my prayer, in fact, we are not expert in the technical parts. So my prayer is clearly mentioned that the inquiry has to be conducted through this honorable court, whether work has been properly executed or not. Whether that component supply, which they are saying that whether it was the quality, the component, quality material or not, that was our part of prayer, my lord.
No, that,
So,
that's
in
why,
fact-
my lord,
in
so-
fact,
sorry, that's why I have submitted, my lord. There can be, my lord, robbing inquiry, my lord.
petitioner
You
cannot
have
be
to prove it that there
technical
is a
expert,
poor
my lord.
quality. Then only your lordship can issue mandamus for inquiry. Robbing inquiry, my lord, I'm sorry, my lord, there cannot be.
All right. We'll pass an order.
My lord, oblige, my lord.
Dictate later. Maybe it will be uploaded, maybe we will pass later, some
Oblige,
other day.
oblige. Much.
Item number 5.
Just write down the name to have argued this case on top. Okay. नाम किरा लिखी दियो पुनः आगे बोलिए it would. Yes.
Lordship, sorry, in item number 5, last occasion, I was directed to take press step. But the press step could not be taken. Pray that the matter may be adjourned for today. In the meantime, I'll take this from the private respondent.
Learned Counsel Mr.
Koyu.
R.
Koyu.
Koyu has submitted that fresh steps could not be taken, full stop. Appellant to take fresh steps to issue notices. Learned Counsel Mr. once more, Learned Government.
Yes, Tapin.
S. Tapin is present. So you have correspond number
1 to 5, Lordship.
1 to 5. All right. List after 4 weeks.
4 weeks.
Yeah. Fresh steps returnable within 4 weeks. List accordingly.
Item number 7.
Lordship, Mr. D. Sora was appointed as a legal aid counsel
Mr.
in this matter. D. Sora
This one. Is not present today.
is not present, Your Lordship.
Paper book and everything is ready.
No, Your Lordship, this is yet to be admitted because there is also a
Not
delay,
admitted.
not admitted. There is a delay of 970 days.
Okay. We have an IA also.
Not, this is a jail appeal, Your Lordship.
Okay.
And also the appeal format, the appeal application itself has not been filed. This, the judgment and order has been
The jail directly.
jailed directly, Your Lordship. That has to be.
Let him be present. Let
Yes.
us hear him on delay also.
Yes, Your
We
Lordship.
can condone it since it has come from the jail.
Your Lordship, yes.
Without his presence.
Yes, yes, Your Lordship. Your Lordship can fix this matter, otherwise after a week, I'll be informing the
Yes, yes.
respective
After a week.
council.
The appellant is not represented today. Learned additional PPM Ms. T. Jing is present. List this matter after 1 week.
Deep, deep.
Item number 8.
Please, Your Lordships. Your Lordships, on the last occasion, this matter was fixed for service to respondent number 1 and 2. So the steps were taken accordingly, your lordships.
Respondent number 1 and 2, it's awaited.
Yes,
Still
your
awaited.
lordship. You,
We'll fix for maybe another 2 days, another 2 weeks. Service
Please,
report is
Lordship.
awaited. Okay, learned counsel, Miss, yes. Your name?
Miss Yuthika Pallavi, your lordships. Why Pallavi would go.
Why Pallavi is present for the petitioner, learned government advocate.
Yes, ma'am. I'm for respondent number 3, madam. They have to serve extra copy, madam. I have yet
W. Wangmo, no?
T. Wangmo.
T. Wangmo is present for respondent number 3. Service report on respondent number 1 and 2 is awaited. Extra copies to be furnished to respondent number 3.
Yes, ma'am.
Okay,
Please,
list after 2 weeks.
please, your lordships, 2 weeks would be fine. Obliged, your lordships, grateful.
Item number 9.
I. The last time I am allowed person, that is complete time.
Madam, may I apprise the court as to how this matter has come up for hearing today on behalf of the petitioners? Yes, IA. Before this instant IA, madam, another IA was heard on 11 of this month, wherein we have made prayer for striking out of one existing respondent and the implement of another necessary respondents, which were granted by this honorable court. And we were granted liberty explicitly in the order of the IA as well as the PIL, directing us to file appropriate application, seeking permission of this court to bring amendment because implement has taken effect. And only after this instant IA would have been moved before this court will pass order at the one go to file the amended petition as well as the amended course title for the convenience of the smooth hearing. So the order is distinctly prepared by this court for PIL also and the previous IA also. PIL 19 of 2024 and the IA 203. Hence, this IA only limitedly shows before the court the particular amendment which we intend to bring.
Okay.
Where is that?
Everybody is present for the respondent?
Yes.
All the respondents are present?
I'm for respondent number
Over.
10 to 15, madam.
Okay, which paragraph amendment?
Paragraph 9, madam. Paragraph 9 of this instant IA.
I number is
279.
Okay. Entire paragraph A, B, C, D, E, F, all the paragraphs?
Yes, madam. Paragraph 9 to 9, A to H.
Okay. You have any objection? Definitely they will have objections. You have any objections?
From government side, my lord, no, my lord, I don't have any objection, my lord, because I feel, my lord, they are necessary party, my lord. Central government, may
But
they-
in IA, madam, we have not been made as party, madam.
Okay.
There is an justification. Madam, the then presiding justice have explicitly made out in the order, had explicitly laid down that since no order has been passed for amendment of the course title, so we cannot do that at the moment. Only when this court will pass order today for filing amended course title as well as the IA, de facto the amendment, the implement will take effect. De jure it has taken effect. De jure it has taken effect. The respondent number 10 to 15, whom Mr. Kato represents, are in a sense and spirit the party of this petition now. Only in the text we have to reflect it. Hence, this IA is preferred.
And you are representing? Do you have any objection? Then we'll allow the IA.
No, I am representing 6 and 7. So we are also filing affidavit that we are not party to that.
Okay.
Since the road which you have mentioned.
Then you will have to file another IA.
Madam, I will submit with all humility. I believe Mr. Jitara have already filed an affidavit long before. I am in the slip of certain affidavit, which I am not available right now.
Today we will file.
Okay. Then I have not received the affidavit. Then in competition wise, sir is delaying before me. So I think prayer may be granted in my favor for implement today. And then their affidavit can be taken into account for delete or whatever it means. Then I will respond appropriately.
No. Just a minute. We generally don't file in that fashion, my lord. Although you have categorically mentioned that this paragraph you have to amend, but what about the other respondent? They may have some objection also, but you have not made them party. I think this is not proper, my lord.
They are already the party.
No, no, in that IA, the present IA.
In the I also they are party. Only the newly implemented parties are not been implemented, and the newly implemented parties have no objection. Only it's
Now,
Mr. Jit
my
Tarak.
brother, he's not the party.
He is the party in the IA.
No, no, we are
He
we are filing
received the-
affidavit that we are not party to the.
Madam, they are mistaken. With all humility, I'm submitting
We are filing.
the council is misconceived because in this instant IA list out all the list array of
My
the
dear, I
parties.
am not talking about your IA. I am just apprising court that I am representing respondents 7, 6, 7 and 8.
Then Mr. H.
But
Obama
they-
interpreted.
They have been wrongly implemented, so we are filing affidavit stating that we are not party to that.
Then
This
this may
is
be
my
taken into
submission.
account after this IA, madam, because they are already implemented. Madam,
Ponder over it.
sorry, madam.
We ponder over it. After some time, we'll take it up.
Sure.
No, we can just let go by everything.
Surely we'll attend.
Ponder over it. I'll take it up after some time.
Definitely, madam.
Item number 12.
Yesterday's matter.
Yes, Lordship.
See, I have gone through everything. I have gone through your submissions also. A video link to cut it.
In this case, Lordship, the accused has already passed 4 years and above days in the court.
Already he has been behind bars for 4 years.
Yes. He has
You have
been,
an ID for bail or you are directly?
no, directly for
taking up that-
disposal, Lordship.
4 years, how many years? How many? 4 years.
Already served 4 year plus already inside the jail after conviction. And before, during the course of trial also, I have already passed two months. So the ground of my conviction is, Lordship, only 164 statement, Lordship. That is the only ground. It's a confessional statement before the magistrate. And during the course of investigation, Lordship, the investigating officer has not found anything, Lordship, independently not finding anything pointing guilt towards me, Lordship, anything, Lordship. Neither in circumstances, there is no circumstances evidence, nor, Lordship, any substantial evidence proved against me during the course of trial. Lordship, during the course of trial, Lordship, the prosecution has produced 12 prosecution witnesses, Lordship, in which none of the, Lordship, prosecution witness has said that I have been involved in the case, except the so-called statement 164, which was recorded by the then magistrate in the 2000. It was a period when judiciary was run by this executive magistrate, circle officer, and EAC, extra assistant commissioner. Since in Arunachal Pradesh, after 2012, only the judicial officer was recruited, Lordship. So during this period, Lordship, this, as further, I am coming to Lordship,
Separation was in 2012,
2012, Lordship.
not before 2012.
Yes. And as for the FIR, Lordship, FIR was lodged on
Separation 2010.
2012, I think.
So who was there in the year 2010?
The year 2000. 2000. Then Buddha is formed in 1999,
Okay.
and thereafter
Judiciary.
UD case was registered.
2000.
Yes, and after coming of that UD that case report, then only FIR was
May I, Lordship?
FIR was-
May I, Lordship?
was low in 1999 itself.
Lordship,
I was in 2010.
let the prosecutor,
Yes. How can I be there without separation?
Let the prosecution part,
FIR
let the
1999.
prosecution start a case.
Hmm?
Let the prosecution part start a case.
No, please continue. Please continue.
Yes. I was saying, Lordship, this confessional statement was recorded by the then circle officer, Lordship, who was the then judicial officer, deputy judicial officer.
yes, I
Since
understand.
judiciary was not separated. Yes, my brother was saying that since 2000, judiciary has been separated already. That is a
No,
wrong
no, that's
submission.
not what he is saying.
Lordship, as per the record.
It was confession statement was recorded by executive cum judicial magistrate.
Yes, in 1900, in 2000, Lordship. Kindly see, initially, Lordship, FIR was lodged on 2 August 1999,
Hmm.
saying that, Lordship, the disease has been killed by someone else, Lordship. The name of the accused is not mentioned in the FIR, Lordship.
Hmm.
And accordingly, the police has registered a UD case. Under 173, it was investigated. During the course of investigation, the police has found that it is not a UD case, it is a murder case. So, case under section 302, what I have stated, 201 and 380 has been inserted, Lordship. And accordingly, charge sheet has been filed. So, on the basis of after 4 months, Lordship, 4 months of FIR, when UD case was investigated, this accused was arrested on 4th of December 1999. 4th December 1999. After four months, Lordship, of the FIR, from the date of FIR. So, from December 4 December 1999, and after about a month, on 6 January 2000, the confessional statement was recorded by the magistrate, saying that you are involved, saying that I am involved in the case. And during the course of investigation, Lordship, as many as about 10,
12.
Yes, during the course of investigation, the police
You
has
stated 12
apprehended.
witnesses.
Yes, police has apprehended as many as 10 persons.
Okay.
In which randomly they happen to pick, saying that statement was recorded, saying whether you are involved in the case or not. So, all of, as per the investigation report, all of them have been not charge sheeted, saying that, and I, out of 10 persons pick up, I have been charge sheeted because on the ground that you have confessed your guilt under 164 statement. Kindly see, and directly coming to paper book, page number 30. Page number 30. I am reading the page number 30. Page number 30 is the Ravidan Sakma, this accused person.
Hmm.
He posed before the magistrate, the then magistrate.
Okay.
I Sri Ravidan Sakma says, on 1st August 1999 at about 200 hours, Sri Puju Sakma of Gautampur village invited me. I'm reading the
Yes,
question.
yes.
This is very important. Gautampur village invited me for the dinner at his residence. Meanwhile, Sri Kaladan Sakma, Sri Potiranjan Sakma and Arundev Sakma asked me to come to the house of Sri Sivaguru Sakma at the Gautampur village. I went to the house of the Sri Sivaguru Sakma as I come to know that my brothers' mothers-in-law get afraid of me when she sees me. To clarify this matter, I have been there at the Sivaguru house along with Sri Kalatan Sakma, Patiranjan Sakma, and Amardan Sakma and Baliram Sakma. Next para. Meanwhile, Sri Bansor Sakma and Sri Sulen Hilu Pulu Sakma of Gautampur village told me that, they told me that one Hajong boy, this is lying on the road near Pakkanala in the drunken mood. Thereafter, we went to see that man at Pakkanala. After reaching the place, I could not recognize the man who was lying on the road in the drunken mood. This man has quarreled with me. This is relevant. They say, as per my deposition, this man has quarreled with me 3 months ago. It is 3 months ago. They say, I have said, allegedly I have said, 3 months ago, over the land in which we have constructed our dwelling house. There is a land dispute, saying that quarreling over the land where we have constructed the house. I thought there could be no other golden chance to take revenge on this man. Thereafter, I pick up one boulder whose weight would be about 8 to 9 kg, and I hit with that boulder on his head. The man whom I killed was Santosh Hajong. This is the deceased person. To mislead the police, I stolen the bike from the house of, bicycle from the house of Sri Moka Sakma's house of Jotipur village and placed this bicycle near the dead body. So it could easily mislead the police and public that the man died of accident. This is the case. I have explained to Sarvidan Sakma that he is not bound to take charges. So during the course of investigation, what had happened? As per the kindly see, I am coming to next. All of this statement of the eye of the case is relevant since there is no independent finding. The conviction is just solely based on this confession statement only. This Sri Amarnath Singh PW 12, page number 46 to 48. This is the statement of the eye of the case, 46 to 48. 46. This relevant part I am reading.
Okay.
Yes. Page number 46, Lordship.
Yes.
Or not, Lordship. I am reading on second line. This is Amarnath 6 statement, the deposition before that. During the course of investigation, PO was drawn a rough sketch map of PO, took photograph of PO and seized Zen's bicycle, one big size stone and one pair of slippers. I have conducted the inquest report over the dead body. Dead body was forwarded to the CAC Dayun for a post-mortem examination. After post-mortem examination, the body was handed over to the relative of the deceased for last rite. During the time of examination, I have examined the relatives of the deceased and come to know that deceased did not have any bicycle. I have locally investigated to find the owner of the bicycle, but one came forward to claim the side bicycle. I have received the post-mortem examination disease. On post-mortem exam, it was found that the disease was murdered by someone with the hard blunt object. I have submitted a report of my investigation to the OC, Officer in Charge Police Station Dayun. On receipt of my report, Dayun Police case numbers, PS case number such and such, re-register enrolled for my investigation. I have, in their kindness, this is important. I send the original copy of the inquest report to MO, medical officer, along with the requisition for post-mortem exam, but same is not returned with post-mortem examination. This is missing, Lordship. Post-mortem examination is missing. That I have traced out the owner of the bicycle, the Santosh Sakma, Bimal Sakma, and Sulen Sakma. At first, the bicycle found nearby the dead body was shown them. They refused to identify. After the investigation, they have disclosed the bicycle belonged to Sri Sushil Sakma, which was kept at the house of the Bimal Sakma and Sulen Sakma at Joytipur. According to them, on the night of this is the incident, 1/8/1999, it is 1999, the side bicycle was stolen by someone who has stolen the bicycle. It is 6 months ago. who has stolen the bicycle, someone, on suspicion they were arrested in connection with the present case. On further investigation, I have come to know from some reliable sources that Ravidan Sakma, Niranjan Sakma, Sushil Kala, Sri Kala Sakma may be involved in the present case. Accordingly, they are called to police station Dayun. During the examination, Ravidan Sakma has admitted this is the case. An offense disclosed the same name of some other person, namely Niranjan Sakma. They say it in the 160, where the police has said, not only him, but many others, Niranjan Sakma, Kala Sakma, Andhra Sakma, Partiranjan Sakma, Budan Sakma, Elias Bolaram Sakma, they were arrested in the present case. During the examination, except Ravidan Sakma, this appellant, have denied their involvement. Ravidan Sakma have denied their involvement. In the police has said, Ravidan Sakma has denied his involvement. Before the deposition of the police investigating officer, accused Ravidan Sakma has confessed, but yes, he says again, he has confessed that he has committed the offense alone.
So the appellant is Mrs. Bini Chakma.
Yes.
No.
No.
Appellant is, yes, Mrs.
Bini Sakma.
He
But,
is not
the-
accused himself.
Accused himself is not the appellant.
No, accused himself is not the appellant.
JLP.
Yes. JLP. Yes. I'm continuing, Lordship. I'm continuing, Lordship. During the examination, except Ravidan Sakma said, Ravidan Sakma has confessed. All of have denied their involvement. Accused Ravidan Sakma has confessed he has committed the offense alone. Accordingly, a prayer was submitted to the JMFC Namsai for recording the conclusional statement under 161 CRPC. Another accused person is not involved as per the prayer submitted to JMFC for discharging them. During the examination, Ravidan Sakma also disclosed that after committing murder of Santosh Hajong, this is the disease, he has stolen the bicycle from the resident of Sulen Sakma, kept near the dead body of the deceased to mislead the public so that public may think that that was the bicycle accident. I have recorded the statement of the informant and other available witnesses under 161 of CRPC. On completion of the investigation, I have found that prima facie cases may be established against under certain section. Accordingly, this exhibits is there, and in the this as per the exhibits in the page number 148, as per the opinion of the MO medical officer, death is caused by heavy hard objects, blunt head.
You have stated that post-mortem report is missing?
Yes, missing, but they have IOS said post-mortem examination is missing, but they have produced this duplicate copy, Lordship.
Page number 140?
Yes, I have seen this. That is present, Lordship. They have exhibited.
Which page?
Kindly see the exhibit in exhibit this post-mortem examination the report. District medical officer. That is dear Lordship. Post-mortem examination report.
Which page?
Kindly see.
In the paper book?
Paper book
27, 29.
27, 29. Thanks. Yeah. Yeah. Post-mortem report 27 to 29.
Okay.
During the I was cross-examined by the defense counsel. During the cross, what he has said, Lordship. During the investigation, I have found that this was killed by the stone, which I have seized and near the dead body. Accused person, Ravidan Sakma, was identified as Sakma. He says Ravidan Sakma has identified the stone which he used for killing the disease. I have not sent the stone for FSL examination. I forwarded stone for seized material to the court, which the search sheet, but the same is not available for. all the seized materials, there was a material was seized, but it was not produced before the court. And the weapon used in this stone, they are saying that 8 to 9 kg. It was not given for this FSL examination, whether it is linked with whether the disease was killed somewhere else and placed before the death spot or not, or that is whether by that stone he has been crushed or not. That is not properly, there is no proper account over how he was killed. Material JMFC search sheet and available today. This in the cross, there is no material has been produced and the stone was not sent for FSL examination. And but same is not available today. I have also arrested Ravid and Sakma on court for confessional statement recorded on January 6 and judicial custody. When the accused was in judicial custody at that point of time, judicial means that the magistrate court. I have not found any eyewitness in the case because only on confessional what I am reiterating. Only confessional. PO during the witness in the present case. I have not found any eyewitness during the PO during the present offense. And accused has confessed his examination at this commission of the present case. In this case, Lordship, as per the IO, deposition of the IO, Lordship, originally they said there was a land dispute, Lordship.
Yes.
As per that, land dispute was the ground on which he has killed. But during this prosecution has failed to prove, neither produce the doctor saying that never been produced, in which out of the 12 witnesses, neither the magistrate has been called for because the depending with advocate was legal aid counsel. So for not properly, even under section 313, 315 sub clause 2, this accused could be competent witnesses, but that application was also not filed. So he could not. And he deposed any evidence before the court during the course of trial. That is one of the lagging, Lordship. And another is Lordship, but Lordship, when the magistrate asks whether you have committed a crime under section 313, he has retracted this confessional statement saying that I was not involved. So in this connection, Lordship, I would like to rely this 313 statement, Lordship. Section 313 statement is 49 to 54. 49 to 54 is relevant. There are many queries in which relevant part is page number 53.
Okay.
Query number 21 and 22. May I read the content?
Yes, yes.
PWD, this court asks to him. PWD 2 says, Para stated that the PWD 12 Para stated that during their examination, except you all have denied their involvement. You have confessed that you have committed the offense alone. Accordingly, a prayer was submitted before the JMFC NAMSAI for recording of your confessional statement under 164 CRPC. Since the accused person were not being involved, a prayer was submitted to the JMFC for discharge them. Do you have anything to say on this? He says, it is a fact that I have confessed the crime before the police. He says, he confessed before the police. All of us were apprehended by the police. We were physically assaulted by the police for confession. That is why he actually confessed before the police, saying that because it was a doubt case, suspect case, all of we were randomly beaten, Lordship, to honor the truth, Lordship. And in this second question, PW12 stated that during the examination, you disclosed that after the committing crime, Santosh Hajang, you had stolen the bicycle from the residence of the Sulan Sakma and kept near the dead body of the deceased to mislead the people that so that public thinks that death was due to bicycle accident. He has recorded the statement of the informant as well as other witnesses provided under 161. Do you have anything to say? It is not a fact. He has not stolen and he has not placed the bicycle over the dead body to mislead the public that the death was due to bicycle accident. That is, it is so this since he could not, due to this negligence of the defending advocate, he could not file any 313 application for this to cross-examination of the magistrate who recorded the evidence and the compassionate statement for retraction, lordship. That is why it could not be. It could not. And the prosecution has not placed the magistrate as a witness. It is not required, but even then, when it is reliability, trustworthiness, reliability 161 is in question, that may be produced. And it was as per the post-mortem report, the magistrate, not doctor, opinion of doctor, it was a hit of blunt object. And it was a blunt hit due to he died. As per even then, the doctor was never been produced before the court, saying that it is this disease has died out of this hit of blunt object. It is, and even what I have submitted, the stone in question was never been produced before the court, and it was never been linked with the death of the deceased person, whether he was killed at that person or at any other place. So, lordship, in the given circumstances, lordship, this in the given situation, as per the 164 statement, lordship, the prosecution has never tried to, lordship, prove the case to corroborate the confessional statement, saying that it was a dispute, lordship. Out of revenge, out of vengeance, he has killed that person. Whether there was any dispute or not, land dispute or not, whereas there is no such land dispute, lordship, then prosecution has never tried to prove that whether by that statement, by that owner of the land, the prosecution could have corroborated the fact that there is a dispute. Out of that animosity, he has killed that person. And it is highly improbable that even because of that dispute, simply by that dispute, after 3 months of dispute, they may kill that person by this heavy stone. It is a case. And that the place where he was said to be murdered is also in the roadside area, Nala area, in the nearby road area. It is not probable that he may be murdered at that such places, where this public road murder can be easily executed in such places, And although, lordship, what I'm again submitting, lordship, although allegation of theft from dwelling house under 380 IPC has been alleged against me, but there is, except confessional statement, there is no witness to show that I have theft that bicycle from that lost bicycle and placed that bicycle in the body, over the body. Even in the given circumstances, lordship, main issue is, lordship, under the given circumstances, lordship, when the accused person has already retracted his 164 statement under 313, in that given situation, court has to see whether further corroboration is required to convict the accused person or not. And there is no scent of even is linked, no intention is proved no knowledge is proof, that the incident of that the criminal act is not proved except compassionate statement, nothing else. So in the given situation, even this 161 statement, 164 statement, what I'm even time and again repeating this, although there is a animosity, grudge in between the party, that is not true. Under the given circumstances, the learned trial court should have been applied their mind and to corroborate the evidence before conviction order is passed. This is since it is a life imprisonment, Lordship. So, under the given circumstances, Lordship, since magistrate was not examined, doctor was not examined, and there are 10% was apprehended, out of which he has been on a charge sheet saying that he had confessed. And he has in the confessional statement, not confessional statement, in the 313, he has clearly stated that he has confessed before the police because police was beating. That is the case. And he has never said he has confessed before the magistrate. So in the given circumstances, my case is very short. I am submitting my some citations, very limited citations also. And firstly, I am a confessional statement, confessional part. Yes. If it is confessional statement, my case is 2012 8 ACC, paragraph 21.
Paragraph 21.
No, page 21, paragraph 25, 26, 27.
Party's name?
Party's name is Rai Sandeep Allies Deepu and State of NCT of New Delhi. National Council.
Yes, Rai Sandeep, yes.
Yes, Rai Sandeep. And next is, I'm again read it.
This is relating to that.
This is a confessional statement. Confessional statement requires corroboration in the given circumstances. And another case is our Guwahati High Court cases, 2022 GLT.
2022.
2022 GLT.
Okay.
Page number 501, para 28. Case number, this party name is Amir Hamza versus State of Assam. This is also on confessional statement required further corroboration. And another case is
these are all on confessional statement.
yes, confessional statement required further corroboration. And my another case is 1973 2 HCC, page number 808, paragraph 25 and 28. This party's name is Kaliram versus State of Himachal Pradesh. In this law point is when this is a law point over the benefit of doubt, Lordship. When two views are possible in interpretation of the fact of the case, the court has to adopt the view which are in favor of the accused.
Okay.
Yes, this is the case. And one more is AIR 1970.
This is on what?
This is on burden of proof. Burden of proof. Reverse burden of proof.
Okay. AIR. We
I-
do not need reverse burden of
Yes,
proof.
that is
Not required.
even then because he could not prove. I am repeatedly saying this. He could not prove because the advocate was LAC, led this legal aid council, and he could not effectively deal the matter and effectively argue the matter because matter was he neither filed to rebut this prosecution evidence under 315 of clause 2 by this entering as in evidence side as defense witnesses himself. He could not. And however, under 313, he has retracted saying that I do not know. This is the case. Under the given circumstances, may I May I read the contents, Lordship? Contents of
Not
the,
required.
all right,
We'll go through it.
yes. That's all.
Okay. Okay.
Only,
And this is like,
only with some 2-3 paragraphs,
yes,
it's okay, we'll go through it.
paragraph I have got remark.
Hmm.
Paragraph is there, this is- That is why my case is very short. On the basis, my only sole argument is, Lordship, on the basis of corroborate this confessional statement, the court has to see the corroboration unless it is of sterling quality. Further, this corroboration is required when there is a statement saying that there is a land dispute. And it was a situation 1990 when there is a judiciary and executive was yet to be separated, and the police has randomly picked them and beaten. He has confessed before the police. So on the basis of confessional statement, that is 161, 161, police statement before police is under 161 only. That is not, and that cannot be treated as evidence. But on the basis of that only, he has been charged-sheeted. This is the only case. So under these circumstances, I would pray this honorable court to discharge this acquitted the accused on that ground.
If we will hear you after 5 minutes, we'll take a break for 5 minutes. Hold up, we'll take a break for 5 minutes. Both are in my chamber only, near my chamber.
Oh, okay.
Yes, Your Lordship. May I please with the submission that the entire records will not be, I will not be submit only 11 portions that is required for justice only. I will. Your Lordship, learned concept of appellant is correct. The conviction is done only on the basis of 164
Yes.
confessional statement. But on his point regarding the supporting evidence, it is available in the record. That is finding of bicycle from the spots and voluntarily admitting that he stolen the bicycle from particular persons, and at the time of the founding of dead body, this accused convict was somewhere nearby with their friends. When the findings of dead body, and he confessed when IO arrested some 8 persons, out of them only this accused admitted the fact that he only killed that persons, killed the deceased. And this statement is 164 is supported by 161 statement also. where he admitted. Thereafter only he was taken for recording of 164 statement. Your Lordship, there are seizure lists of one bicycle, one stone, which was here taken as a weapon of offense, one big stone, a pair of slipper / chapel, and doctor opined the cause of death, who conducted the postmortem, is due to the hitting of blunt object over forehead by causing serious injury. That was only a cause. And finding of this boulder, this stone, is supporting and indicating the weapon of offense. It was found from nearby dead body, where the body was lying. And when we take this as in cumulative way, the sequence of offense, and later after the admissions and conduct of this accused, safely we can come into conclusion that this particular appellant has caused the death of that deceased persons, for whom he was charged under section 302 IPC 380 for stealing the bicycle from from the house of one person. Then 201, to try to mislead the police that death was caused by the vehicle accident, not by him. And bicycle, the son belongs to him also. That's why he has stolen the bicycle and put that nearby dead body. Your Lordship, here most of the prosecution witnesses are hearsay only because nobody seen the incident. There were they were not an eyewitness and they were not present at the spot also. Here, connecting link is page 34, PW3. This is a person who present the seizure witness, a seizure bicycle, to somewhere 1 year back to one person, namely, that is, married this person. It is not long.
Yes.
On oath. I know all the accused persons. They are from Diung. Accused Ravindran Chakma is also known as Pagla. This Ravindran Chakma is a prison convict of this case. I am from Gunanagar. The incident occurred about 8-9 years back. After when this deposition was recorded, it was occurred before 8-9 years. Then I was a monk and also a student at that period. My mom are residing at Diung. They requested only to present them a bicycle, which are available at Buddhist monastery. My cousin Sulen wanted the discarded cycle for carrying paddy, etc. So I gave them one old bicycle. After 1 year of my presentation to them, the bicycle was lost and recovered and found near the dead body of the deceased. Actual owner, this witness is the actual owner of the bicycle, who present bicycle to one person, and from that positions only, this convict has stolen and put nearby dead body. Your Lordship, then page 55, PW 11. Oh, sorry, it's 45, 40. He is one Bimul Chakma.
Mm.
On oath, I had a bicycle which I used to keep under our changar, traditional hut. One day, before about 25 years, somebody has stolen my bicycle and kept the same near dead body at the main road of Gautampur. This cycle was connected that one, there were chances of
This bicycle
ownership.
was belong to Bimal Chakma.
I had a bicycle which I used to keep under changar.
Yes. This is the position of Bimal Chakma.
Yes, Bimal
And it
Chakma.
indicates that this bicycle belongs to Bimal Chakma.
Yes.
Then please come to page 35. 35 is Sulen Chakma.
Yes, Sulen
Sulen
Chakma.
Chakma. Can you read the?
I had one bicycle which was given to me by my elder brother.
Okay. So
I used to keep the bicycle under the changar where we used to reside. One day our bicycle was stolen by someone and the same was found at Gautampur, nearby dead body of the
okay.
Santosh Hajang.
And so this bicycle, same bicycle belonged to him also. And then he says that
it's
given to him by his elder brother, Chinanda Chakma. Isn't it?
Yes, they are brothers, same father. That means they are residing at same house.
Okay.
So they,
And
this particular witness also says our bicycle, not my bicycle, our bicycle.
Okay, they are family.
Yes.
But then this Sushil Chakma is different again. Page 34.
I know all the accused persons. They are from Dion. Accused Ravindran Chakma is also Espagla. I am from Gautam Nagar.
The last, yes, my new.
After 1 year of my presentation to them, this person I have already.
Yes. So the original owner of the bicycle is Sushil Chakma.
Yes.
Thereafter came to this family. Three
Yes.
person says that our vehicle.
Thereafter come to one Sulen.
Yes. Sulen.
Then the position of Sulen is at page.
Bimol clearly said that I had a bicycle.
Yes.
So he is owning the bicycle.
Page 35.
35 is Sulen.
Sulen,
Sulen
yes.
also say I had one bicycle.
Yes, I had one bicycle, which was
And page 45, Bimol also say I had one bicycle.
which was given to by my elder brother.
Hmm.
I used to keep the bicycle under Changa where we used to reside. One day bicycle was stolen. Someone from a dead body, Santosh Hajang was murdered by someone. I was arrested in the press case. This is also claiming ownership. Here, no why it is mentioned that further it was possession was delivered to the present claiming accused PW.
So accused stolen from their house. Yes.
It's okay. They are from the same family according to you.
Yes, same place.
Same father, they are
Yes.
brothers. Okay, it's okay.
Then you also postmortem report was exhibited by the eye of the case. Doctor was not examined, and magistrate was also not examined. But it is not fatal to the prosecutions. When the report is clear, there are many judgments that there always their examination is necessary. That is not there. Postmortem, your Lordship has already perused. It is yes. Doctor opined that it was cause of death was something hit by blunt force.
Upward force.
Yes. Then (313). That is in page number 49 to 54. And that will come to the page 52. Question number 21.
Yes.
Here, accused was asked that the PW12 further state that during their examination, except you all have denied the involvement. You have confessed that you committed the offense alone. Accordingly, a prayer was submitted to JMFC Namsai for recording of your confessional statement under Section 164 CRPC. Since other accused persons were not found involvement, a prayer was submitted to the JMFC for discharging them. Do you have anything to say? Anything to say on this? Yes, his reply was, it is a fact that I have confessed the crime before police, as all of us were apprehended by police, and we were physically assaulted by IO for confessing. Then, Your Lordship, next page. Question 24. Do you have anything more to say as defense statement in regards to this case? His reply was, on the date of incident, I was at the residence of one of my friend. During that night, one Kaladan Chakma and another Pratiranjan Chakma, who are my friends, came to me and they informed that the person is lying on the bed. Then I, along with Kaladan and Pratiranjan, went to the place. We have seen that Santos Hajang was lying dead on the road. Later on, police apprehended all of us and detained us in custody. I was taken to court at Namsai, where I was told that my case is closed, but I am again arrested and detained in custody. Your Lordship, from this, what inference can be done that these named persons were together at the time of finding the dead body. And earlier also, other PW says they had a dinner together at one of the house. Where he was also, and that here, Your Lordship, photograph of place of occurrence, page 19.
Yes.
Page 19, 19. F, D, F, D is dead body of the deceased. F is a stone. G is a bicycle. Then J, house of Sri Bhagya Kumar Chakma. House of Bhagya Kumar Chakma. It was somewhere nearby. So, Your Lordship, further I like to take you. Let's revisit the 164 statement. It's in page 30.
Hmm. Why? We have gone through it.
Yes,
Point out a specific line. Instead of going through the entire statement, we have gone through it once.
here, Your Worship, before putting signature, registered signature, I have explained to Sri
Hmm.
accused that he is
Yes.
not bound to make a confession, not bound to make a confession. And let that, if
This is the certificate, but
certificate after recording and prior to that, giving replies and all, read over and contain full and true account of the statement made by him. So, Your Lordships, in 313 CRPC, he has improvised his statement that he was assaulted by
by
police.
police.
Yes. Trial went for almost 10, 12 years. Prior to recording of 313 statement, yes, he could have sufficient opportunity to refute the 164 statement or to deny the content thereof. But he has not taken any plea. Last, it's 313 is a conclusion of prosecution evidence. Thereafter, it was recorded. And to support his contention, he was not adduced single defense witness also. There is no defense witness. If there is some weight in his 313 statement, he could have explained or supported by some other witness also. 313 CRPC purpose is to giving an opportunity to the accused that he is not involved and he is nowhere connected in the case. And further, accused is given an opportunity to adduce the defense witness, if any. So that part was not done. That omitted. And my contention now is 164, when it is recorded and corroborated by some evidence, admissible evidence, like findings of bicycle, seizure stone, then opinion of doctor, then IU who filed the charge sheet, his evidence value cannot be discarded also fully. It cannot be, police evidence is also sometimes reliable. So in some cases, there is no civilian to put signature in seizure memo. So police personnel who went with the IO, they have to compel to put his signature at the spot. Some cases, police evidence are not discarded completely at all. Here, confessions corroborated by independent witness, the voluntary reliability, question of voluntary reliability, if court satisfied that this was not under any inducement, threat, or something
Okay.
warning, that can be reliable. It can be a basis for a sole conviction, sole basis for a conviction. Your Lordship, this is a case of Calcutta High Court, reported in the year 1981. Sorry, 87. In this case, Honorable Kolkata High Court alertly dealt with the concept of 164 statement.
Yes.
Here ratio is second page. I'll direct up to para 1, 2, 3. Page 2 of 10. Here issue was whether the judicial confession of the appellant was voluntarily and reliable. Second question was whether the confession was corroborated by independent witness. And rest other is not connected in this case. But question number 4, whether the appellant was involved in the robbery of taxi, here stealing of bicycle. And this the property of this is. So here, so Desinanti was deducted that firstly, the court held that a confession, if voluntarily and truthfully made, is an efficacious proof of guilt. The court applied a double test laid down by the Supreme Court in Sakaria versus State of Rajasthan to determine the admissibility and reliability of the confessions. The court found that the confession was not caused by any inducement, threat, or promise, and that it appears to be a probable catalog of events that fit in with this rest of the evidence. The court held that the confession was corroborated by independent evidence, including the seizure of taxi, driving license of deceased, and the such and such. The court found that this evidence supported the appellant's confession in several material particulars. The court held that appellant actively participated in the strangulation, that is here, killing of deceased, and here, this is regarding common intentions. The court found that appellant's conduct so that he shared the common intention with other accused person to kill the deceased. The court held that the appellant was involved in the robbery of the taxi and the property of the deceased. The court found that the evidence clearly saw that the appellant, along with others, committed the robbery of taxi and paper relating to the taxi. Final decisions, next page. The court dismissed the appeal and affirmed the order of conviction and sentence. Here, something is matched with this present case. Of course, there is no common intentions. But robbery and stolen of bicycle, they are matched with each other.
Okay.
So I will rest with this much only. In this,
just come back to page 54.
Paper book.
Page 54.
Paper book.
Yes. Where the accused, on being asked in 313, stated that
154.
I, along with the last page 54, last, I, along with, can you read that? Page 54.
Yes.
Yes, last, then
Yes,
I, along
yes.
with the last question, 24, second last question, and last paragraph, last sentence, that I, along with Kaladhan and Pratiranjan, read that sentence, where he has stated that
then
we have seen the Santosh Hajong was lying, Santosh Hajong, who is the deceased, was
Yes.
lying dead on the road. He was lying.
Was lying dead on the road.
Is there any finding that he was injured at that time? Because he was already lying there before the alleged hitting of the stone by the alleged accused person, the convict. Whether the person who was already lying.
Yes,
having
already
any injury,
in
any-
lying means in dead condition. So that police was called for. immediately please us to the spot.
This is what the accused says, that when he, along with his friend, went there, on getting an information that somebody is lying there, when they went there, and this person stated here in 313 that he was lying dead.
But 164, he admitted that
This
In,
is what 164 what I'm saying.
he took revenge.
No, that is in yes, 164 he says. But
Yes.
here he says that he was lying dead already. He was lying there.
Yes, yes.
In 164 CRPC, he stated that since he was lying there, he took advantage. This is a good opportunity for him to take revenge, and he did it. But then here he says that he was lying dead already when they visited.
That way, Your
Is there
Lordship.
any other person stated in 160 stated or deposed that when they found, because along with him there were some other persons also. He was already lying. Anybody, any of the suspected person at that time have stated that he was having injury also when they found that he was already lying there. Because
No, they all are saying that
Okay, yeah.
they reach the spot when, but this person was always lying on the road.
Okay, petitioner,
they
Mr.
do not
Tapak,
They do not know
okay,
about the
just a
incident.
minute. So this is would be for your advantage. Anyone stated that because when they heard that somebody is lying there, when they went there, they found that person was lying. Any of the person stated that he was having injury also. Because otherwise, as per 164, he says that he took advantage and went alone, and he alone has hit with the stone. But then since he was already lying, any of the witnesses has stated who have seen at that time that he was already having injury mark before the present accused person, present convict, has assaulted him or killed him with stone. He was already having injury? No one. Okay, that was just, not prepared.
Okay, then.
Somewhere I found that they saw the injury. They saw the injured person lying on the road.
Only injured person. But,
Yes. But they were not aware whether he was.
Where do we find that?
Now only say I saw the dead body of the deceased at this.
No, that is only after he was already killed by the present accused. So before the present accused person, as per his 164 statement, took advantage and killed, prior to that, he was already lying. At that time, whether he was already having injury or not, that I wanted to know. We'd like to know if he had already injury. Mr. Tava, it is not your case that he was already dead, lying dead? It is not your case?
Prosecution case rests on that fact the person was found lying on the
dead
road.
After
Then when
he
police
assaulted.
came, they came to know that this person was already dead.
Mhm. Okay, so
Nobody saw the incident.
That is why,
PW9 Lord.
because PW9,
Only PW9 you see?
page,
PW,
So
page 41 of.
What,
paper.
what
He said,
what my brother
It's,
is trying to say is that it is not your case that he was already lying dead? And he was already dead before the,
I'm not on that.
okay. You should be on that. That's why he's asking.
Amardan Satma.
Hmm.
It is not a fact that I was sitting on the 1st August at my residence.
where is his chief? Okay, I do not remember.
I have told the police that one Bhubaneswar Shakma entered Shakma camp. They have said one person, they are the first person who
Yes.
who saw that. This-
After
this-
he has died.
Yes.
Yes,
But there are two incidents.
yes.
Once
Later-
he was
let-
found
later-
lying and once he was found dead.
Later on, this informant is PW1. Time is PW1 is informant. This Abumia Hajong, not Abumia Hajong. This informant is time is
That is
yes,
all,
Mahendra Hajong. Mahendra Hajong is someone else.
that is only after
It
he
is
was
on-
found dead.
That is on next day. Abumia Hajong lost the empire on
No,
2 August 1999, and it is when he saw this is 1st August 1999. When this is I have told to the police, yes, say, I have told to the police that one Bhubaneswar Shakma and Sunglu Shakma came to the house of a Danudar Shakma. They were told that one person is lying at the main road of Gotampur. I have not told before the police that we come back from the residence of the Danudar Shakma and we went out to our residence. I have told before police that on the next day, this has come to my knowledge that one Santos Hajong was killed. They have seen. On the next day, only this FIR was known.
that is only after he was found dead.
Yes.
My query was, in the evening
Hajong
after
was
they,
killed by someone. I do not remember
okay, they are not-
where Ravidas
Not-
Sakma was.
It's okay.
They also found lying dead.
there is two incidents.
Mm.
One in the evening, they heard that somebody was lying there. They went there and saw he was lying there. And thereafter, only this accused person, the convict, took advantage and then he came back probably alone and he can kill him. So morning, the other person found him dead only. So
Yes.
I wanted to know the person, the deceased person who was lying there in the evening before he was killed by the present alleged accused person. Whether he was, when he was lying there, whether he was having any injury or not. Anyone has seen or not, because not only the present accused person, the other person have also seen, they went together. So that I wanted to know. That should have been your plea, if there was any.
Yes, injury was inflicted before death or after death.
Yeah.
I cannot say.
You won't say.
Yeah, because
It's been asked.
That is not your plea.
because there's nothing in that regards
Yes.
in the records.
It's not for you,
Hmm.
it's for him. Whether he has taken the defense.
I am unable to find that.
Okay.
So that is not your case. Hmm.
Exactly, I am not unable to find it.
Okay, okay, so. Okay.
Learned Council heard Learned Council, Mr. T. Tapak. for the appellant and learned additional PP, Mr. G. Tado,
Yes.
reserved for judgment and order.
Obliged.
Item number 9.
So, just a minute. All those citation.
Yeah.
The print and this.
Sure. You have given one copy, no? One copy. Yeah, there you are. So they have given.
No.
Here, citation and written order.
Okay, here's given. Okay.
You can take it from here also.
That's fine.
That red ink is your question.
Okay. Okay.
That's for the number 10 to 13.
It was, no?
Or you mean high it? No, not 15. We are not.
No?
Yes.
Okay.
Yes.
We are ready, madam.
Okay. Yes.
Madam, the objection which in the first time all the learned councils were putting forth, I believe with all humility we are immune against this objection because that objection were already their no objection were already noted in the previous order. Hence, we were given liberty to file this petition only to bring amendment.
Where is the order?
Where
is the order? You are given liberty.
Yes. Order dated 11/11/2025.
Please read.
Paragraph number 3, I will read. On the prayer made by the learned counsel for the petitioners, he is granted liberty to file an appropriate application for consequential amendment of the PIL. The order for filing of the amended cause title of the PIL shall be passed as and when orders are passed in the application proposed by the learned counsel for the petitioner for amendment of the PIL so that all the amendments can be done at one go.
So who is not arrayed as a party here and who is not required to be arrayed as a party here?
Respondent,
Who are the respondents in this appeal?
respondent number 5 was struck off and respondent number 10 to 15 were impleaded.
10 to 15?
Yes, and madam, that newly impleaded respondents are listed very explicitly in the instant IA in paragraph number 9H.
Respondent number 5 was struck off. Here in the appeal, we have
IA.
respondent number 1 to 9 and respondent number 5 was struck off.
Sorry, madam, I beg
In
pardon.
this, not appeal.
IA.
This, no, in this PIL,
Yes,
in this petition, PIL petition, we have respondent number 1 to 9 and respondent number 5 was struck off.
yes, madam.
Yes. So you do not want the respondent number 7 in the PIA?
Respondent number 7 is there. 7 is there. Only 5 was supposed to be struck off and it was ordered as per our request also.
Whom you do not want as respondent? Out of all the respondents here, whom you do not want as respondent in the IA? That is what I could get.
Okay, respondent number in this IA, we are just praying for impleadment. Prior to this IA, another IA was already filed and disposed of. In that, we have made prayer for impleadment.
Where is the order?
I'm so sorry, madam. I haven't.
Have you annexed the order?
No, not here to avoid the bulky petition, but it is there on record.
To be deleted without.
This is there. This is there in the.
IA 203 was there, but I haven't attached that.
Fire 203.
I haven't attached it.
In this.
Not, madam.
No, you'll have to annex. How we'll get to know who is required?
Because anyway, that same order was reflected in parent petition PIL 10. The parent PIL 10. Yeah, parent PIL.
The order.
This is also not attached here. We have but then we have referred in this IA.
How can I hear orally and how can I understand anything after hearing orally? That order is reflecting.
Understood.
That order is reflecting that.
If you're,
You give me the order?
if this court direct us to do as such, we can take a step.
No, why should I direct? It's up to you.
But anyway, madam, if I will,
Other courts may not require.
with all humility, I will submit just for sustainable practice and not to create.
I cannot pass any order based on oral submission. You are referring to this order, that
Yes.
order, then where is the order?
But that order, this PIL is listed along with this IA only, madam. So I was of the bona fide belief that your lordship may be in availability of the
I have-
order.
Which means what you have stated that IA number 205 was
Three.
disposed of.
203.
Disposed of. So according to that, we do not have to implement this respondent.
Hmm.
So where is the order?
But that order is also reflected in the parent, in the order of the PIL, same order.
Where?
Order dated 11/11/2025. The parent PL under
Please
which,
read, please
okay.
read. Where is it reflected? Order dated 11/11.
okay. I will read from second paragraph onwards, madam.
Yes.
It is to be mentioned that by an order passed today in the connected IA, the name of the respondent number 5 in this PIL has
That
been,
is there. He has been deleted.
yes, yes,
Number 5 has been deleted.
deleted.
But other respondents whom you do not want?
We do not intend to, we don't propose to delete any more respondent.
Okay.
Just this respondent.
Only respondent number 5.
Yes, it has been.
And who is appearing for respondent number 5?
Mr. Saikia Rentu, he was there.
He was absent in the last hearing also, and today also is absent.
Okay. Okay.
And madam, may I with all humility just read?
You are for which respondent?
And for 6 and 7.
You don't want to give notice to respondent number 6 and 7?
We have served already. This IA, instant IA notice was served in advance.
Okay.
May I please go? You also my senior Mr. RCK, the standing counsel both.
No, it's okay. His name has been deleted. It's okay. That is not required.
Yes.
Whom have you arrayed as respondents in the IA? Everybody.
In the IA, paragraph number, page the.
Page 8.
Page
Page
8, my
eight.
lord. Page 8.
Respondent number 1 to 7, 1 to 9.
Oh, 10 to 15.
10 to 15 in page 8 of this instant IA. I've stated like this.
So everybody has received notice?
Except my lord, 14 and 15, notice has to go, my lord, 14, 15.
They are the private party, NHIDCL. 10 to 13 is represented by Learned Counsel M. Kato.
Page?
Page 8. Page 8. The chronological order are as follows: 10, 11, 12, 13. 10, 11, 12, 13 are the proposed parties who need to receive notice, and 14, 15 as well. But 14, 15 has to be taken by, they are the private party. 10 to 13 can be received by Mr. Kato DSGI, and they are in receipt of this IA also. Notice of this IA has also been served to them before filing this.
So these are the new respondents?
Yes,
10,
madam.
11, 12, 13, 14 and 15.
Yes, madam.
So have you issued notice to them?
Yes, only the notice of this IA was served, that we are filing this, and they were present even throughout the hearing of the previous IA, by which we have secured the order for implement and striking.
In this IA, have you
Yes,
issued notice to
yes,
them?
yes,
Have they received the notice?
yes, yes.
My lord, as I've said, my lord, 14 and 15, my lord, notice has to issue, my lord.
10 to 13 have received.
10 to 13, no issue. Mr.
Please issue
Kato.
notice to 14 and 15?
Yes.
Okay.
I will take a step.
Then we'll hear you.
Okay.
Notice the court has to issue.
Madam, may I with all humility again submit?
You do not want to issue notice to 14 and 15?
Yes.
That is what I was asking.
Because,
All along I was asking. So you do not want to issue notice to 14 and
yes, yes. Only
13 and 14 or 14 and 15?
14 and 15 are the private parties.
Ah.
So what can be done today is this: a notice can be issued to 10 to 13, who's already present here. They can receive DSGI can receive notice on behalf of these union parties. Then I will serve them the extra requisite copies of the amendment petition so that they can respond. And before it,
In whatever manner you want to.
yes,
issue.
then I will take a step
Only the
further.
notice has to be served, that's all.
Yes, then I will take further step by private way for 14 and 15. I will serve amended petition because they also has to be arrayed here in the next hearing.
Okay.
I believe I have not traveled the bench.
Not at all.
Thank you.
Learned Counsel, Mr.
Margia Lombi, M. Lombi.
M. Lobby is present for the applicants. Learned Counsel, Mr. Learned Additional AG, Mr.
R.H. Navamal.
R.S. Navam is present for respondent number, how many?
My lord, IA respondent number 1, 2, my lord, 1, 2, up. 1, 2, 1, 2, 1, 2, 1 to 4, 1 to 4, my lord. Public Work Department.
1 to 4,
1 to 4.
comma, Learned Counsel makes.
Then 7 also, I think. 7.
And numbers 10 to 13.
MCOT.
RWD.
He was present. Learned DSGI, Mr. M.
Eight,
is
eight.
present for respondent number
10 to 13.
9.
10 to 13. Learned Council, Mr.
You have to
G.
mention.
Karat is present for respondent number 6 and 7. Notices may be issued to respondent number 14 and 15.
Yes, 14 and
Can be
15.
within 2-3 weeks?
Yes, 3 weeks can maybe done.
3 weeks, yes. In any manner you want to issue notice,
I will take a step definitely.
list accordingly. Arun, main case, what about the main case? PI?
I will take a step to file, I will file amended petition now.
Okay.
I will file amended petition and I will serve all the parties. And when I will be serving notice to 14 and 15, I will attach that as well.
PIL to any.
Your lordship may not pass any order in PL, my lord.
Just
Only, yes,
list it.
my lord, along with.
PIL protocol listed along with the IA will.
And madam, the amendment may be allowed as
List this
proposed.
matter along with the IA.
No, not now, not.
Let notice be served.
Okay.
Matter is over or we'll have to come back?
DB over, my lord.
DB is
DB
over.
over.
May I, Your Lordship?
Yes.
Your Lordship, I beg to mention item number 13, Your Lordship. This matter to be listed after 1 week, Your Lordship.
1 week.
I have to file Your Lordship affidavit, Your Lordship.
Let the matter come up next week, Your Lordship.
Okay, next week, yes, Lordship.
As agreed by both the sides, list this matter after 1 week.
Organize, Your Lordship.
Item number 16. I've taken consent from the opposite council.
Okay. Learned Council Mr. G. Koto, with the consent of the other side is prayed for adjournment, list the matter when you want
After 2 weeks.
after 2 weeks.
But compared to most of the number of eleven, they are conducting council is the previous cycle. The matter will be fixed for 4 December.
Learned Council, adjournment has been sought on behalf of Learned Council Mr. P.J. Suikia. This matter on 4 December.
Degree of this. Make the mention letter number 70. Forget to out station.
Out of station. Adjournment has been sought on behalf of
Nothing of the TV matters.
Learned Council Mr. P.D. Nair. List this matter
9th December. 9th December. 9th
9 December, on 9 December.
Well, sir, I beg to mention for admission hearing for tomorrow.
Second hearing tomorrow,
Yes, no, sir.
possible tomorrow? Tomorrow.
Yes, Lordship, desire.
Mention number 10 on behalf of the council and received out station.
Adjournment has been sought on behalf of Learned Council Mr. L. Parme as he is out of station. And consent has been taken from the other side. Consent to nullify.
3 weeks, 3 weeks.
This is matter after 3 weeks. Consent part to continue.
And there was an interim,
Shall remain enforced in the next date of.
maybe continue. Then
Your Lordship, I would like to mention item number 22. As the leading counsel, Mr. X Gyati, for the respondent is absent today. This matter may be fixed after 2 weeks, Your Lordship.
Adjournment has been sought on behalf of Learned Council Mr. X. Gyati.
X Gyati,
Is this matter after 2 weeks?
2 weeks, Your Lordship.
my lord, I also beg to mention item number 23 on behalf of standing council.
Adjournment has been sought on behalf of 23. Learned Standing Council.
Consent has been from the board part, from the other parties, for 1 week.
Learned Standing Council who is
El Parme.
L. Parme. Learned Tenant Council Power, Mr. L. Parme. This matter after 3 weeks.
1 week.
After 1 week.
Must duly oblige.
Lordship, I beg to mention item number 19.
Hmm.
Government, they have filed the counter affidavit. I need to file rejoinder.
Learned Council Mr.
R. Koyu.
R. Koyu has submitted, has paid for time to file rejoinder against the counter affidavit filed by the respondent. This is matter after
Up to 3 weeks.
3 weeks.
Lordship, there is interim.
Interim order shall remain in force till the next date of listing.
Item number 1.
Here, my lord, in this matter, my lord, I was asked to get instruction, my lord. So I have not yet received any instruction, my lord. So may I predict this matter? Here, my lord, notice may be issued, my lord. In the meantime, I will get instruction.
Learned Council Mr.
IBAM.
I-Bum is present on behalf of the respondent. Learned
No,
Government
petitioner, I'm the petitioner.
on behalf of the respondent. Oh, sorry, petitioner, comma. Learned Government Advocate Ms.
T. Wangmu, my lord.
T. Wangmu has submitted for time to obtain instructions as directed by this court. List this matter after
After 3 weeks, my lord.
3 weeks.
Your Lordship, there is an interim order, it may be continued.
Interim order shall remain in force till the next date of listing.
It's much appreciated.
Item number 2.
Well, the challenge is basically the impugn recovery order issued by the superintending engineer, PHE Alo Division, Alo Circle. My lord will kindly come to page 48 for a moment. '49 is the type copy, my lord. Dated, my lord, yes. Page 49. May I read, my lord? Yeah. Dated 15th October 2025, whereas engineer Kirbasora, the then executive engineer, PHE and WS Division Alo, has overdrawn salary of rupees 32,48,682 only with effect from 0104/2001 to 10/7/2021. Now, my lord, see, the incident is of 10 years now. And the destiny of a human being as usual. Unfortunately, he left this heavenly world on 10/7/2021. Now the applicant is the widow of late engineer Kirbasora. Now the question is, after the death, my lord, the process for reconciliation of the account was on for settlement of the pensionary benefit because the wife is entitled under the old pension scheme, even those children who are unmarried, girls especially. So here, now, my lords, kindly come to page 27 as I have shown, my lord, to the impugn order. So pursuant to the expiry of late engineer, this order was issued, my lord, 10 November, page 25. Page 25. Under provision of pension CCS rule para 39, sanction for rupees 14,25,280 rupees only is hereby accorded for payment to Srimati Nyai Sora, legal wife of Kirbasora, EPHE and WS Alo Division, who expired on 10/7/2021, being case equivalent to leave salary of 300 days earned leave, which was at his credit at the time of expiry. Now, first thing they have given it, there is no quarrel on it. Now, my lord will kindly come to page 28. 26, 26, my lord will come, still in the annexure 1 series.
Page 26 here.
26. Under provision of pension rule 64, sub-rule 4, clause A, Roman 1, provisional pension of rupees 5,28,760 rupees only is hereby sanctioned for payment to Srimati so and so, so and so, so and so. Till then it is okay, but there is no quarrel on this. Now, my lord, kindly come to page 26.
26, I have just.
28, my lord. 28. 28, my lord, type copy is at page 29, my lord. Thereafter, the pensionary process was started from here. 25th April 2022, my lord. 2022, my lord.
Okay.
These were the documents which they have sent. Now, my lord will come to page 31. Page 31. This is type copy, my lord. Now, here the Director of Audit and Pension, my lord, Government of Arunachal Pradesh, returned back the proposal. My lord will kindly come to the operating portion, that is 1 and Roman 1. The pay fixation at rupees 18,470 plus 5,400 as on 01/01/2006. Initially under 6 CPC appears in order. However, pay may be refixed at 18,970 plus 5,400 grade pay as and so and so after giving benefit of 1 additional increment in terms of so and so. As per order in para 2, sub-para. As per order dated so and so dated 19/7/2000, the departmental examination as per CPWD manual has been enforced to engineer service under department. It is observed that there is no entry regarding passing of department examination for AE as well as EE in the service sheet, but periodically increment had been granted regularly up to so and so 2003. As such, kindly re-examine the case and the excess withdrawal of pay beyond 01/04/2001 due to non-passing of departmental examination till attaining the age of 50 years may be recovered with an entry in the service book. After refixation and regulations of pay revised, last pay certificate, revised circulation sheet and revised form 18 may be submitted in duplicate duly authenticated by the head of the office. So, my lord, now the problem is started from here, where there is a CPWD manual. In one case, I think my brother Tapin was opposite side to me, opposite side of me. Which that case? Tamoli Tako case. So there, that I forgot to bring it, my lord. So in that case, any amount paid excessive for 5 years cannot be recovered. A Tagung Ketan case was also there. Well, I will not place those citations below. Now, what had happened is, this page 32 is a very tough English. Who has drafted, I don't know, because I was also, in a fix. So I was forced to refer to the Black Law Dictionary and find out the meaning of certain words. I'll try to explain this. Very interesting. I don't know, because this kind of literary orgasm, in my state, I'm so happy to find this soul. Solicitation for exemption of recovery amount. My lord, will come 05/01/2023 letter. Pursuant to this rejection letter, then this has been written. Solicitation for examination or exemption of recovery amount on humanitarian ground, my lord. Now, my lord, reverse bestowing a highness devotion to your bounteous, my lord. Bounteous means generously. That's the literal meaning, my lord, which I could make out. I have the honor to put forward before generosity the following few lines for your kind measures. We write, my lord, kind considerations. Well, the wording is so nice. I was deeply engrossed in this. For kind measures from your employer and please. We normally will not write for your kind consideration and necessary action, please. But the quality of literature which this writer has employed something very interesting. That sir, my husband abruptly had expired on 10/7/2021 as unknown disease, but not recoverable sense. But that means, my lord, the literal meaning is period in which the body recovers from the illness. That is the meaning of this word. So normally, my lord, when I read something like I do these things. So then, other hand, department asks for a huge amount to recover due to non-passing of departmental examination. In this juncture, I am assiduously, grotesquely. This, kindly see this.
It's not required. You can carry on. I can follow.
Unconsciously fall of children's fall down and anxious for my dependent of spring per dim gobet and veshilet. The meaning is per dim for each day. That means each day. Gobet, a small piece of food. Veshilet means to alternate or waver indefinitely. That is the literal meaning. My 6 numbers of children are going to college. As such, huge amount is very badly needed for their future life. Failing which their life automatically turns to ruinous and simultaneously darkness. In view of the aforesaid quintessence, my lord, the pure concentrations, my lord, I sincerely, with folded hands, pray to your bounteous kindly bestow me an opportunity to provide Gobet all my dependents, so that very essential to exempt the recovery, the said amount.
She's asking not to withdraw the amount.
No, she is praying literally, praying for condonation of non-passing of the departmental examination as mandated in the CPWD manual, especially for the
Not to withdraw the, not to take back the.
not to take back the money, my lord.
Or excessively withdraw.
Excessively, whatever it is.
Sure.
Yes.
I got it.
So the poor, my lord, it was so painful to read this. Kindly see, then the department has processed this letter. My lord will find it page 33. One time, because Indian rules, my lord, and the laws are sometimes very inhuman, my lord. It says 28 January letter, my lord, page 33, granting one-time waiver exemption from passing of departmental account examination thereof. In inviting a reference, your letter number dated so and so,
Rejected.
it was rejected in this context. Now, then what had happened? Here, my lord, this poor lady, then the superintending engineer writes to the chief engineer. Department tried its best for exemption of recoveries in view of non-passing of departmental account examination in the case of late Kriba Sora, XE, which has not been considered. Hence, you are requested to recover the excess amount drawn to late Kriba Sora, so and so, that the instruction has gone. Now, person there to, my lord, the petitioner has submitted a representation saying that please do not do now. I am a widow and with 6 child, and then how I will manage if I this pay. But then, my lord, being a law-abiding soul, has returned some money, my lord. Kindly see, my lord, where is the challan? A challan, my lord will kindly at page 43. Because the subordinate officer, executive engineer, has to follow the order of the chief engineer. So therefore, this letter was written, my lord. So, recovery of drawl, page 43, my lord. So she was initially asked to deposit 7,86,264. Being a law-abiding soul, she has complied with my next page 44. So then she deposited 7 lakhs, and thereafter again she was asked. Then, my lord, next, my lord, kindly come to page 47, my lord. Another letter by the chief engineer, the joint director of audit and pensions. The file paper was sent, but then again it was sent back. my lord will kindly see 1 Roman 2,
Page
The-
45.
page 47, my lord.
Okay, yes. What
I read one paragraph only, my lord. 1 Roman 2. As per latest clarification from AR dated 28 to 2025, the assistant engineer promoted from the post of junior engineer are not covered under the assured career progression scheme nor modified assured career progression scheme, as they are already covered under the time bond scale. Since both the scheme cannot run concurrently, the MACP granted to the incumbent dated 18/9/2017 shall stand forfeited. And since the officer has already earned 3 promotions with financial benefit, he is not entitled for any further financial upgradation under the time bond scheme. So then what had happened was, pursuant to this impugn notice was issued. My type copy is page 49.
Okay.
Now, page 49 is the bone of contention, Miller. Whereas so-and-so, then executive engineer PHE and water supply division ALO has overdrawn salary of rupees 32,048,682 only with effect from 01/04/2001 to 10/7/2021. Therefore, Nyai Sora, wife legal hire, is hereby directed to deposit the said amount to the government and government account and submit the deposit receipt to this office for further proceedings of the pension papers. Now kindly see, the gross amount is 40,34,946. Now the question comes, how this poor widow can repay back? Because you, on the other hand, you have not processed the pension. Even from the pension also you could have, from there you could have recovered. But then she has been asked to deposit this much of amount. Now provisional pension would have been there. From there the recovery could have been done. So you have not done it. Now what the law says on this issue. Now the law says there cannot be any retrospective recovery of the money unless if it is not by misrepresentation or by fraud from the employee. Now, my lord, kindly see the detailed guidelines on this, page 50, my lord.
Page 15.
50, my lord. My lord can peruse this after,
Yes, yes.
while passing the order. Page 50 to 51, 50 to 52, my lord. Detailed guidelines. Now, 53 is also there, my lord. That is, Ali, sir. My lord, my younger says I should read one paragraph from page 51.
Okay.
The assisting so that he should feel happy.
Okay.
My lord, kindly come to page 51, serial number 4. The Honorable Supreme Court, while observing that it is not possible to postulate all situation of hardship which would govern employees on the issue of recovery, where payments have mistakenly been made by the employer in excess of their entitlement, has summarized the following few situations wherein recoveries by the employees would be impermissible in law. Recovery from employees belonging to Class 3 and Class 4 service, Group C and Group D service. Recovery from retired employees or employees who are due to retire within, 2 is important for me, my lord.
Yes.
Within 1 year or the order of recovery. Recovery from employees when excess payment has been made for a period in the excess of 5 years before the order of recovery is issued. This is also important. It comes in my rescue. Now, rest I will not read. Now, this judgment basically, it is popularly known as a whitewasher judgment, Muhammad Rafiq's judgment. But this particular my lord, was the Class 3 and Class 4 employee. So now the opposite counsel might say this notification will not be applicable, particularly for this, but the apex court, my lord, recently, my lord, the Jogesar Das versus the district magistrate, Cuttack. has clarified the position. Just you have this, I have one copy, I'll give you. Here, my lord, in this case, on the similarly situation fact, similarly based documents. Yes, Jogesar Sahu, my lord, and other. You have the copies? Yes. So the distinguish, he will also make, I will also make, my lord. But there is one colonel, my lord, in paragraph 10, Colonel B.J. Akbar, retired colonel. He also faced the same situation. His case was also exempted. Then that Said Abdul Qadir teacher, my lord. That was also. But my lord, kindly come straight. My lord, para 7 is important, my lord. The issue falling for our consideration, page 4, my lord.
Okay.
The issue falling for our consideration is not about the legality of the retrospective promotion and financial benefit granted to the appellants on 10/5/2017. The issue for consideration is whether recovery of the amount extended to the appellant while they were in service is justified after their retirement, and that too without affording any opportunity of the hearing. I am pausing for a moment, my lord. The husband expired on 10/7/2021. So therefore, there was no occasion of serving any so cause notice or affording me an opportunity to give the rebuttal. Simply serving a notice to the LRs will also not do. And in this case, my lord, no notice was also sent, but quintessentially, my lord, have seen the consequences of what they done is mumsimus. Mumsimus in the sense they are retorting back to their old tradition systems of government working. So they don't know whether the natural justice has to be followed or not. In the even, my lord, it is not embedded in the statute or the act or the rules, but principle of natural justice must be followed here. Here, this has they have not followed. Now, my lord, kindly see para 8. The law in this regard has been settled by this court in the Katina of judgment, rendered time and again, Sahib Ram versus State of Haryana, Shyam Babu versus Union of India versus M. Bhaskar and B. Gangaram versus Regional Joint Director, and in recent decision in the matter of Thomas Daniel versus State of Kerala and others. Now, my lord, we can skip the para 9 also, my lord. It's not very big judgment. This court has consistently taken the view that if the excess amount was not paid on account of any misrepresentation or fraud, my lord, para 9. Here, my lord, kindly see, this court has consistently taken the view that if the excess amount was not paid on account of any misrepresentation or the fraud on the part of the employee, or if such excess payment was made by the employer by applying a wrong principle for calculating the pay allowances or on the basis of particular interpretation of rule stroke order, which is subsequently found to be erroneous, such excess payment of emoluments or allowances are not recoverable.
There's a rule also that disbursing officer from disbursing officer,
Yeah, it is their duty.
accountant.
Yes.
That can be.
Finance and accounts officer, it is their duty. So now it is held that such relief against the recovery is not because of any right of the employee, but in equity. Well, this word equity is also very interesting. The equity, the concept of equity, my lord, it has developed from the Chancery of England. From there it came, and my lord, in 1962, there is one judgment by our Guwahati High Court, which has further propounded this, the concept of equity, and this has widely been accepted by the apex court also.
Okay.
That is the greatest contribution from our High Court, in the realm of judiciary. In exercising judicial discretion to the provide relief to the employee from hardship that will be caused if recovery is ordered. Now, similarly, my lord, there's all this paragraph, everything, my lord, that para 10 also, Sahib Singh is also reiterate, Thomas Daniel, paragraph 10, 11 is also same thing, my lord. My lord, kindly come to para 11 in the page 6. Because so that my brother Tapin will not take a ground that Muhammad Rafiq case was a class 3 and class 4.
Okay.
In column 11, in para 11. In Colonel B.J. Akara, retired versus Government of India, this court considered an identical question as under. The last question to be considered is whether relief should be granted against the recovery of the excess payment made on account of the wrong interpretation, understanding of the circular dated 7/6/1999. This court has consistently granted relief against recovery of excess wrong payment of emoluments, stroke allowances from an employee if the following conditions are fulfilled. So these are the judgment. A, my lord, kindly see. The excess payment was not made on account of any misrepresentation or fraud on the part of the employee. My lord, here this principle covers.
Yes. Okay.
Because my husband has that, my lord, expired on 10/7/2021. There was no such misrepresentations. Now, B, my lord, such excess payment was made by the employer by applying a wrong principle for calculating the pay and allowances or on the basis of a particular interpretation of the rule stroke order, which is subsequently found to be erroneous. Now, my lord, see whether this is what we in our own normal parlance we call it is a last nail to the coffin. So this clause B also fortifies my argument, my lord.
Okay.
No, my lord, this and ultimately, my lord, that said Abdul Qadir is also covered. No, my lord, undoubtedly all those principles I will not say. My lord, Muhammad, para 13, my lord, will see page 10, State of Punjab versus Rafiq Masih, White Wasser, popularly known as, my lord.
Just now you have referred.
Yes, yes, I refer to that. So, my lord, finally, para 11 and 12, they have decided, Honorable Apex Court has discussed and settled the law, and para 12, my lord, I read para 12 for the convenience of this. For the aforestated, we are of the considered view that the appeal deserves to be allowed. Accordingly, we allow the appeal and set aside the order of the High Court, and in consequences, the order dated 12/9/2023 and 08/09/2023, by which appellants were directed to deposit the excess drawn areas, are set aside. Now here, my lord, the person, the appellant, my lord, appellant was a stenographer, my lord. Stenographer, my lord, she is a whole group B gazetted and group A officers only. So therefore, my lord, then what had happened, my lord? It was his case. He was given promotion. All the monetary benefits were extended, my lord. Then the learned district judge allowed. But then what had happened when it was sent to the High Court for approval for additional fund, the High Court rejected. Then against that backdrop, the petitioner Jogeshwar Sahu, he filed the writ petition before the Honorable Orissa High Court, and the single judge and division bench affirmed. So no, there should be an excess recovery. Now, against the backdrop of two judgments of the Honorable Orissa High Court, the Jogeshwar Sahu, the appellant, has preferred this SLP before the Honorable Apex Court. Apex Court interfered. So therefore, my lord, today, tentatively, although I have covered on the merit as well, my lord, kindly suspend this recovery, impugn suspend order, my lord. Page 48, dated 15/10/2025. Yes, ma'am. Kindly suspend this. I don't know, my brother Tapin.
Notice may be issued at this stage.
At this stage, notice may be issued. Okay, then I think here's a case to state the impugned order.
So, at
No,
this
it will be
stage,
very difficult.
at this stage, I don't know.
Money is recovered. It will be very difficult.
It's very difficult, my lord.
Yes.
Poor lady, widow is suffering.
Learned Senior Counsel Mr. Nidara for the petitioner, Srimati Nyai Sura,
Yes, sir.
and learned Government Advocate, Mr.
S. Tapin.
S. Tapin. Tapin, no?
Tapin.
Tapin, Mr. S. Tapin. Government Advocate, no?
Senior government.
Senior Government.
Well, this word tapin in our language is the bat. So he can fly. So my brother always flies.
Video conferencing is on, others I also could have added something else. For respondent number 1 to 5.
1 to 5.
The petitioner is aggrieved by the order passed by the superintending engineer, PHE and WS Circle Bene within bracket Alo for recovery of rupees 32,48,682. Full stop. The petitioner's husband was serving in the department and he has passed away. And now when the petitioner has applied for pensionary benefits, it has come up that the petitioner has to pay the aforementioned amount as the amount was excessively withdrawn. Full stop. It is submitted that there was no misrepresentation on the part of the petitioner, and the petitioner who is not receiving any pensionary benefits from the department after the demise of her husband will suffer irreparably if she has to pay the excess amount withdrawn. Full stop. It is further submitted that the amount was the petitioner had overdrawn. It is further submitted that the petitioner's husband has overdrawn the salaries excessively on the misunderstanding that he has been promoted after appearing in a departmental exam, appearing in one departmental examination or 2, 3,
I think two departmental.
appearing in 2 departmental examinations. Full stop. The learned counsel for the petitioner has also relied on the decision of the Honorable Supreme Court in Jogdeshwar Sahu and others versus District Judge Cuttack and others, reported in 2025 INSC 449.
449, yeah.
Wherein the prayer of the appellants to exempt from recovery of excessively drawn salary was allowed. Okay.
Yes, ma'am.
Huh?
Yes, ma'am.
The learned senior government advocate has submitted that notices may be issued at this stage. So after considering the submissions at the bar, it appears that the order impugned may be stayed until further orders. Okay. Thereby, the order dated page 49, no?
49, 15. 15,
Thereby, the impugned order dated 15/10/2025, being order number PHECB/PF-74/2011-12 dated Bene 15th October 2025, passed by the superintending engineer PHE and WS Circle Bene within bracket Alo is stayed till the is suspended or stayed?
State.
Is stayed till the next date of listing. Okay. It will continue thereafter. Notices to be issued, returnable within 4 weeks.
I'll furnish extra copies during course of.
Extra copies to be served, list accordingly.
Item number 3.
My lord, here kindly issue notice the same subsequently because pension has not been processed. And then my lord, only request is kindly come to page 24, my lord. My lord, this kindly continue with the provisional pension. That is the only prayer in this.
Notice may be issued at this stage. Because there is no interim prayer, Lordship. Only notice has to go, Lordship.
Hey, tapin ase na, prayer ase tu.
So you are getting your provision?
No, they have given it, but they have discontinued. So this should be discontinued, my lord.
No, we will have to hear and we will have to fix an elaborate order.
65. We can give it this.
We'll have
My
to
lord, this can be because law is settled. There is no this thing. I'll read one thing. There's,
Which one? Same Jageshwar?
no, another,
Sardas?
no, notifications.
CCS. Pension rules.
Cancel rules. We have extracted from the book, Milot,
Mm.
original book, Milot. It's a bulky. 64,
Okay,
5.
CCS rules.
Yes, CCS.
Okay.
5A.
5,
A.
A.
Next page.
68, 5A.
Yes. The payment of provisional pensions shall not continue beyond the period of 6 months from the date of retirement of a government. Yes, ma'am.
No, it's 64.
64.
64, 5A.
64, 5.
64 provision pension for residents other than departmental or.
Correct. Kindly come to 5. The payment of provisional pensions shall not continue beyond the period of 6 months from the date of retirement of a government servant or from the date of submission of Form 5 by the government servant, whichever is latter, and if the amount of final pension and the amount of final gratuity had been determined by the head of office in consultation with the account officer before expiry of say period of 6 months, the account officer shall issue pension payment order. Directed the head of office to draw and disburse the difference between the final amount of gratuity, so and so. So kindly this continue, Milot, kindly. They have already continued, they have given the provisional pension, Milot, 6 months.
And they have discontinued.
Yes, sir. And this can be continued. At least some soccer she will receive, Milot. At least. I think.
At least on this very aspect, Lordship. Let me come with the instruction of the incidents of the case. We don't know, Lordship.
Fine.
What is the exact situation here?
Well, but.
Again, London Senior Council.
Sir.
Council notice likhi di baat.
So, I am not designated yet.
Oh, okay, really? Sorry.
I think
London Council.
by the grace of God, it will happen sometimes.
So far I heard about disconnect with,
Okay.
about I don't know, for forms maybe taken up much. I don't know much.
It can be part of the records, Milot, because it can be part of the records, Milot, because we keep on relying.
You need it.
And I have extra copies. Grateful, Milot.
Item number 4.
Yes.
Lordship, item number 4, Lordship, here this writ petition has been filed for simple direction by this honorable court for non-inclusion of my name in the electoral roll, Lordship. The election, the panchayat and the municipal elections are to be carried already. Notification has come out. They are not including my name in the electoral roll, Lordship. The provision says otherwise. I have filled the form and I have submitted it, Lordship, but they are reluctant to include my name, Lordship. That's all my grievances.
Any order passed earlier?
No, Lordship, this is first time coming up before your Lordship.
Okay. Will issue notice or will wait?
No,
instruction?
Lordship, here I'll seek for disposal of this matter, Lordship.
Today itself.
Lordship, why? Because
Dispose it of today.
Yes, sir, Lordship. If their name is not enrolled in the municipal electoral roll, your Lordship, the petitioner may approach the appellant authority and it's under appeal provision under Rule 15, your Lordship.
Okay. But the panchayat rules, or you have the local.
Lordship, there is a municipality act rules, Lordship.
Let me see.
Lordship, I'll be relying on Arunachal Pradesh Municipal Election Act 2009
See the-
and rules, Lordship.
You can approach the municipality.
Yes, sir, Lordship.
Well, I'll dispose it of them. All the respondents
Same
are
way.
present today.
Your Lordship. And here's appeal provision under Rule 15, your Lordship, may got right. Same again.
Okay, then I'll start dictating it. Learned Counsel, Mr. J. Ginny
Lordship.
is present for the petitioner.
Same here.
Amina Toko.
Lordship, for appellant, Lordship.
Petitioner.
Petitioner, Lordship. Mina,
This is WPC, no?
WBC, Lordship.
Same again.
Srimati Meena Toko, who has filed this petition with prayer for inclusion of her name in the electoral roll of the.
Ward number 8.
Where is the prayer?
Page starting from page 12, Lordship,
Page 12, okay.
Lordship, page 13 is the main prayer, Lordship.
With nala inclusion of a name to Katirasu, with prayer for directing the respondent number 3 means within bracket municipal electoral registration officer hyphen Mero, capital MERO, bracket close, to consider and decide the petition submitted by the petitioner Srimati Meena Toko on 13/11/2025 strictly on its merits and thereafter to include her name in the electoral roll for ward number 8, Itanagar Municipal Corporation within bracket IMC bracket close, as mandated by section 23(2) of within bracket 2 of the relevant act read with rule 15 of the election rules 2011. Stop. Enabling the petitioner, continue enabling the petitioner to exercise her constitutional rights to contest, participate and file nomination papers before the prescribed deadline of 24 November 2025. So we don't have time to issue notice.
Yes, Lordship.
Learned Senior Government Advocate, Ms. A. Apang.
Lordship, no, I'm MS Anju for Standing Council State Election Commission.
Anju.
N Anju, Nani Anju.
N. Anju, sorry.
Lordship,
I keep
for state.
keep on asking your name. N. Anju and Learned
P Pangu, Your Lordship, for respondent number 2 and 4, Your Lordship.
for respondent number, I go to 1 and 3 and P. Pangu for respondent number 2 and 4.
2 and 4, Your Lordship.
It is submitted on behalf of the respondents that the petitioner may approach the
Appeal provision under Rule 15(1), Your Lordship.
may approach under the provision of I have two notifications with me. Arunachal Pradesh Municipal Election Act, 2009.
Yes,
Or the other one is rules 2011. which-
2011.
2011.
2011.
Approach as per the Arunachal Pradesh Municipal Election Rules 2011. Rule 15.
Yes, 15(1), Your Lordship.
15(1). And submit an application in Form 2 to the Municipal Electoral Registration Officer for inclusion of name. Inclusion of her name. Full stop. Considering the submissions at the bar, the petitioner is thereby, the petitioner may, or granted or may.
Lordship, here, Lordship, the appeal, if we go for appeal, Lordship, the time will be over, Lordship. Here, the 15 days time has been given, Lordship. Now here, Lordship, they are not considering my application, Lordship. So, Lordship, may kindly direct to consider my application, Form 22. Now, regarding the rejections,
You can approach before the applicant authority, Your Lordship.
that will come after my application is rejected, Lordship. There is no written,
Okay, then, Your Lordship.
Okay, so I'll give a direction to the, whom do you want?
Lordship, MERO, Lordship, respondent number 3, Lordship.
Specifically,
Yes,
respondent number
municipal
3.
corporation.
I deem it appropriate to give to direct the respondent number 3 to accept the application dated, which one?
Lordship,
13.
13, Lordship, page number 22, Lordship.
Page number
Nine, starting from 19, Lordship.
dated 13/11/2025.
Your Lordship.
Okay. Submitted by the petitioner. And to consider the application on its merits and in accordance with law.
Lordship.
In terms of the above observation, this petition stands disposed of. Right?
Lordship, I'm appearing only for respondent number 1, that
Oh,
is
for
State
number
Election
one.
Commission.
And who is appearing for two?
No, 2 and 3.
2 and 4, Your Lordship, I'm
Three?
appearing.
Is anybody appearing for three?
4, it's urban development. Sorry, UT.
It's okay.
It's
And
okay.
two, three to continue, without three, we'll dispose it off. Otherwise, time is ticking. Time is ticking.
Lordship.
Time will start running out.
Item number 5,
Lordship, here also simple direction is required, Lordship.
Say.
Same, Lordship.
But what number is different?
What is different, Lordship?
What number is
What number will be different, Lordship?
And the petitioner will be different.
Petitioner will be different.
It's okay.
Same,
respondents?
same.
What is the what number and date?
19.
What number 19?
What number 19, Lordship?
What number 19, date of application?
17, yesterday, Lordship. We have
17/11.
17.
Dispose of 8.
Yes, these two are disposed of.
Obliged.
You take back your papers.
Lordship can keep it, Lordship.
it can be kept
For
in the file,
reference.
is it?
Can-
In the file,
No, you
You
can
can-
issue.
Lordship, I'll
Okay.
take it.
Not required.
Yes.
Okay, leave it, very quiet.
Lordship may kindly quote the sections also, Lordship. Section 23 and 15.
Good, I think.
Lordship, that particular may be quoted in
15A, no?
Lordship.
15, I have
I
quoted.
scrap of that, Lordship, particular
Okay.
sections.
I had to quote koi dibat kiya hai.
Or something.
And after 2011, 2009, 2011 to quote koi dibat hai. Tik kora hai sir.
Section 23 and Rule 15, Lordship. That I have plague marked it, Lordship.
Okay, section 23 of which one?
Municipal Election Act 2009 Lordship, and 11, Lordship. Rules is 11, Lordship.
Rules is 11. I think you're rather not confused.
Lordship.
Again, I'll have to change the order.
Lordship, I have plague marked in the
2009 of key flag mark for also पढ़ा दिया.
obliged.
item number 6,
My lord, here, my lord, petitioners, my lord, were appointed as junior engineer in the year 2001, my lord. And subsequently, petitioners were given officiating promotion, my lord, as assistant engineer, my lord. And my lord, thereafter, my lord, DPC, my lord, with find it in page 82, my lord. DPC was held on 19/8/2024, my lord. And DPC recommended, my lord, petitioner's name for promotion to the post of assistant engineer, my lord, prospectively, my lord, assigning the date of promotion from the date of DPC, my lord. Then, my lord, petitioners, my lord, filed representation, my lord, and department, my lord, they have identified the vacancy, my lord. It's because we have been promoted in the promotional quota, my lord. So, my lord, thereafter, my lord, promotional seniority list was issued. So we have made claim in objection, my lord. And impugned final seniority list was issued, my lord, on 12/2/2025, my lord. It's in page number 101, my lord. So, my lord, here what happened, my lord, there was, we have been given officiating promotion against the promotional quota of 2017, my lord. 2017.
Where is the promotion order page?
It's in page number 88, my lord. I have, yes, my lord, I have,
And page 101 is
it's a final seniority list. Final seniority list.
101.
Yes, my lord. So, my lord, in 2017, my lord, we have been given officiating promotion, my lord, against the promotional quota, my lord, and which has been identified by the department also, my lord. year-wise vacancy was identified. So, my lord, in final seniority list, what happened, my lord, in 2017, there was only one direct recruitee, my lord. So, department has applied rota quota rule, my lord. And my lord will find is in page 101, my lord. No, my lord. Yeah.
Yes.
Yes, my lord. Here, my lord, from my lord, serial number 17, my lord. My lord, if rota quota is applied, my lord, serial up from it start from serial number 17, my lord, and thereafter, my lord, 103, my lord.
Okay, serial number 70.
Yes, my lord.
Okay.
And thereafter, my lord, there is one direct recruitee, my lord. That direct recruitee name has to be after serial number 17, my lord. Thereafter, my lord, it should be all the petitioners, my lord, who have been given officiating promotion, my lord. However, my lord, here, my lord,
Their name is below the direct recruitee.
one direct recruitee after that promotee and direct recruitee, my lord. This was done, my lord.
Alternative.
Yes, alternative. How, and private respondent, my lord, they were appointed in the year, recruited in the year 2019.
So what is the interim order you want now?
My lord, I have no interim prayer, but notice may be issued.
Or you do not have interim?
Yes, yes, just to highlight the case, my lord.
Learned Counsel, Mr.
El Nosi, my lord.
L.
Nosi.
Nosi.
Yes.
Is present for the petitioners. Notices to be issued to the respondents. Returnable within 4 weeks. Extra copies. Learned Counsel, Mr.
G Tarakpur 2.
G. Tarak is present for respondent number
2 and 3.
2 and 3. And Learned Government, Senior Government Advocate, Government Advocate, Miss K. Wangchu. Wangmo is present for respondent.
1 and 4.
1 and 4. List accordingly. 4 weeks, Dilana, returnable within 4 weeks.
My lord, private respondent is there, my lord. I'll take a step.
Sorry?
Private respondent is there, my lord. I'll take a step. Yes, yes.
Item number 7.
Oblige.
Lordship, may I please, Lordship? This case is basically for assessment for land compensation, Lordship.
Compensation, yes.
Land assessment, Lordship. Direction for assessment for land compensation. Since Lordship, the project is going on, Lordship. Already contractor has been appointed, but previously I am told that there is no compensation provision under the law. That is why there cannot be any compensation. Then later on, as per RTI information, we come to know that contractor has, because we are having objection over this execution of without any compensation over my land. So kindly see this page number 38. Page 38 is the agreement note. Agreement copy. This type copy I am.
38.
Yes, 38. Type copy of the agreement for settlement. This is MS Kenge Construction is the contractor who is executing the project. And a group led by Lokam Tapok. Lokam Tapok is leading the land affected families. So contractor has made an agreement that sum of rupees 50 lakhs out of 11 crore plus amount. Project cost is 11 crore plus. So this, as per agreement, that going on, but I am not in on this party group led by Lokan Tapok. So I am single out. So later on, I come to know as per this kindly see guidelines. This is a government of India project, vibrant bliss program. The guidelines. Kindly see page number 29. As per the page number 29. Yes, 29. This is the letter written to the Secretary Arunachal Pradesh. This,
Page number 29.
page number 29 by the this by the Union of India Ministry of Home Affairs, saying that in such projects this kindly see this subject is there and down below the above I am reading the para 2. Above proposal sanction is accorded subject to the following conditions to be filled by the states. Number one is latest standard operating procedure SOP relating to PMGSA issued by the Ministry of Rural Development shall be followed while implementing the road project, including any amendment in the SOP issued from time to time. So accordingly, this PMG SY guidelines is applied in the project. So what PMG SY says, guideline says, kindly see page number 40 is the PMG SY guidelines. Page number 40 and paragraph number, I'm
Page 4040.
4040. This is the Pradhan Mantri Gram Sadak Yojana program guidelines.
Yes.
Then kindly come to page number 52 is the paragraph 6.12. 6.12 how lane is acquired. Page number 52 of WP. And
Paragraph 6.
paragraph 6.12. 6.12 may I read the consent. This is the operative.
Yes.
Yes, this is the operative procedure for provision. It will be responsibility of the state government, district panchayat to ensure that the lands are available for taking up the proposed road works. It is the responsibility of state government or panchayat to propose road works. A certificate, that land availability certificate accompanying the proposal for each road project work. It must be noted that PMJSI doesn't provide fund for land acquisition. It does not, however, mean that acquisition cannot be done by the state government or at its own cost. The state government may also lay down guidelines for voluntary donation, exchange, or other mechanism to ensure availability of land. The process of making land availability for the road works should serve the common goal and also be just and equitable. The details, next page, details of land made available should be reflected in the local land record to avoid disputes. This thing has not been, procedure has not been followed by this who puts this scheme. That is why without our consent, the scheme has been put and approved from the government of India, and accordingly program has been implemented. Those who are raising objection has been taken into confidence by this by way of agreement. But when I approached before the authority by series of complaints and representations for inclusion of my name has been singled out, and the rest of the land affected family has been already settled. So at this stage, Lordship, in terms of this law, because this is a case of this proprietary right.
Where is your application?
Application
For
is,
compensation,
yes.
any application?
Kindly see, my compensation application is from page number 77 to 81.
Page number?
77 to page number 81. This is the page number 77 is a Dara Take complaint against Lokam as a PA holder of Kenge Construction before the Deputy Commissioner. Here, I have requested him to compensate my damaged garden, June Zoom cultivations and properties as per. And again, DC before Dara Kaki before the Deputy Commissioner, Executive Engineer and Kenge Construction, contractor concerned, Kenge Construction, the contractor.
The entire construction company.
Yes.
So you have raised a complaint.
Yes, complaint, saying that my land should be acquired. Since they have accommodated others by way of personal accommodation.
So, okay. you
Again,
can-
series of complaints.
My lord, this Vibrant Village, this is a rural road connection project. There is no provision for land compensation. So the state government, they approach the village, the panchayat, so they donate the land. So then the department constructed road. So this agreement is between the contractor, this is the government has nothing to do. If there is some understanding between the landowner and the contractor, that they can done, that is not our outlook.
No, he is not in the agreement, but his land has been acquired. So
That has to be proved, whether he have land or not. If some villages, they have enter into agreement with the contractor, the why he have left that, whether he have land or not.
okay, then
Notice may be issue.
we'll issue notice.
Yes.
Mr. Learned Counsel, Mr. T. Tapak is present for the petitioner. Learned Counsel, Mr. G. Tarak, Learned Government Advocate,
Standing council RWD.
Standing Counsel, Mr. G. Tarak,
Standing council RWD.
RWD Lihiboliburi, Standing Counsel,
2, 3, 4,
RWD, Mr. G.
2, 3 and 4.
Tarak is present for respondent number 2, 3 and 4.
Four.
And Learned Government Advocate, Ms. T. Wangmo, no?
Yes,
T. Wangmo is present for respondent number
1 and 5.
Notices to be issued, returnable within 4 weeks, extra copies to be furnished, list accordingly.
Interim order is that on the next returnable that interim order that may be
The
heard.
prayer for interim order may be considered on the next. return.
Next.
What is the interim order?
Road
Because,
is now,
in case payment is all the payment is released, then I will be nowhere. That's why.
Okay, okay.
if contractor executed road, he has to pay.
Since the contractor is ready to bear the cost
Well,
with the landowner. Allah.
Item number 8.
My lordship. Lordship, the writ petition is filed challenging the electoral of inclusion of non-APST in the Vijayanagar Panchayati Raj election. Your Lordship, there is a notification published by the government of Arunachal Pradesh by Department of Panchayati Raj that prior to the inclusion of the name in the electoral, one has to declare in Form 4 that he or she has to be a local indigenous of the state of Arunachal Pradesh. Either then apart from that, there is no provision for the non-APS to be enrolled in the Panchayati Raj regulation. Your Honor, may please come to the notification, page number 45.
Okay. Can we dispose it like the earlier petition?
No,
No.
No, Your Lordship.
no, Your Lordship.
Notice can be issued, Your Lordship.
Lordship,
Issue notice?
Lordship, the matter is very urgent as they already have notified the Panchayat election.
Yes, yes, on 24/11.
Yes, Lordship.
So how can I give you urgent relief urgently? What is the most fastest way of your relief?
Lordship, may please stay or suspend the Gram Panchayat electorals that I have included. There are 17 Gram Panchayat electorals.
No, Your Lordship. No.
No. How can I suspend the electorals? What about the others whose names are appearing?
Moreover, Lordship, may
Please you notice short date, short
Y-
date.
Yes, Your Lordship. So that may be given, Your Lordship.
Today we are on 18.
18.
So you'll come with
2 weeks, Your Lordship.
2 weeks.
Within-
But elections are on 24/11.
Lordship, we can come up with instructions.
Yeah, we can come up with instruction.
Short date, So before notices are issued, you can come up with.
Yes, yes.
And
Yes, Lord.
simultaneously will issue notice also? No. Okay. Learned counsel, Mr.
T. Tatak.
T.
Tatak.
Tatak is present for the petitioner, C. Ati Bosai Yobin, whose name is not included in the electoral rolls of village, which one?
Lordship, it's not, the prayer is not like that.
Again.
Lord-
নামটা লিখে দিতে হবে। Ati Bosai Yobin, learned counsel, Miss P. Pangu is present for.
For respondent number 1, 3, 4, and 5, Your Lordship.
Number one, government advocate.
Yes, Your Lordship.
Government advocate, Miss P. Pangu is present for respondent number 3, 4, and 5.
No, 1,
1, 3,
3, 4, and 5, Your
4,
Lordship.
and 5, and learned government advocate or standing counsel?
I am standing counsel for State Election Commission.
Standing counsel for election commission, state election commission, Miss A. Ajung is present for respondent number
6.
6. Notices to be issued to the respondents returnable on short date.
Short date,
Short date, Your Lordship.
Lordship.
26.
21,
26, Your Lordship.
20.
20 near the last 26. Okay.
26.
26. No?
26.
Yes, Your Lordship, 26. Yes, 26 November.
Meanwhile, the respondents may also obtain instructions relating to the, what, instructions relating to what?
Instruction relating the inclusion of the
The
revision list of the Vijayanagar circle.
inclusion of the petitioner's name in the revision list of.
No, Lordship, the non-APST, non-STP residing in the Vijayanagar, they are the settlers.
Okay, okay, okay. Relating to the, please.
In violation of the notification dated 2/6/2019. Form 4.
Relating to what? What is your prayer?
My prayer is, Your Lordship,
Notices to be issued, instructions to be obtained relating to what?
in relation to the verification of the Form 4.
Verification of form 4
Yes, inclusion of the new voter list,
and inclusion of the.
voter list,
voters list.
voter list in the electoral,
In
the Panchayati electoral,
the Panchayat electoral roll, list accordingly.
Publish, Your Lordship.
most of this.
Item number 9.
May it please your lordship. Your lordship, by way of this writ application, your lordship, the petitioner are challenging the eviction proceeding which has been initiated against them under the provision of Arunachal Pradesh Public Premises Eviction of Unauthorized Occupants Act. Your lordship, before I delve into the matter further, I would like to bring certain necessary facts, your lordship, which is necessary to adjudicate this petition, your lordship.
Why should I adjudicate it now?
No, the interim prayer is there. So for the purpose of adjudication,
What kind of interim prayer?
your lordship, for staying that proceeding, your lordship.
What proceeding?
Eviction proceeding is initiated against me, your lordship. I have
Only you, against. who?
against 4 of the petitioners, yes, against us.
All right, yes.
Your lordship may kindly come to page 16, your lordship. These from page 16 to page 37, your lordship. These are my allotment applications, your lordship, which we have filed in the year 2022, before 2 years, your lordship. Thereafter, along with all the clearances certificate from the forest, town, urban department, and town planners. Now, your lordship, at page 30,
Page 16 to page 22 are your allotment application.
applications along with all the annex, all the clearances from the respective department of the government.
Along with clearances.
Clearances from the respective department of the governments.
Okay.
Now, your lordship, at page 38, your lordship may see there is the list
Page
of
3030?
38.
Okay.
38. Your lordship may see, in respect of the same locality, There are list of persons whose allotment applications has been approved.
Okay.
Is 38. 1, 2, 3, 4 are those whose allotment applications are approved. We are at serial number 6, 7, 8, and 9. The writ petitioners are. It is showing under process, Your Lordship.
Okay.
Now, Your Lordship, meanwhile, while my application was pending, on 17th July 2025, that is at page 40, Your Lordship, a circular is issued by the
So this page 38, at page 38, where are the petitioners at? Serial?
6, 7, 8, and 9.
Then page 40?
Page 40 is that during the pendency of my application, Your Lordship, a development taken place. In page 40, Your Lordship would find a circular issued by the Deputy Commissioner, East Siang District, wherein the occupants and all the other departments who are residing in that particular locality, that is Agam Colony, were called for the meeting. Now, next is the minutes of meeting, that is at page 41 and 42.
Okay.
There, the threadbare discussions taken place, wherein the respondent number 3, that is Deputy Commissioner, has taken the decision that that particular colony would be taken up for a new project of under Smart Cities project. Some certain buildings that is 24 units of building will be constructed there, Your Lordship. That is everything is happening subsequent to my application, during the pendency of my application. Now, all of a sudden, Your Lordship would find at page 43, Your Lordship, 43 to 46. These are the notices which has been issued against me under Arunachal Pradesh Public Premises Eviction of Unauthorized Occupant Act. There was showing pose why no action should be taken against me for eviction.
43.
43 to 46, Your Lord.
You are occupying the premises.
This Agam Colony only.
Agam Colony where?
It is in Pasighat, East Siang District. Now, thereafter, Your Lordship, we challenged that proceeding and prayed for dropping the proceeding, and our written objection is also there from page 47 to page 60 is our written
So, have you
object.
approached the district judge?
Your Lordship, there
When
is
you're asked for to be.
under Arunachal Pradesh Public Premises Act, the appellate authority is there. This is DC. DC has been conferred with the appellate power. But that too, when the proceeding is initiated and if any decision is taken, then against that decision I may approach it. But here I am for the quashing of that proceeding, Your Lordship, because since the similarly situated people have been allotted the land, at least if that land is required by the government, then at least I cannot be evicted like an unauthorized occupant. That is because
I got your point. Yes.
Lordship, firstly, I would like to say, Lordship, this writ petition itself is not maintainable as it has been filed in, it's a premature Lordship. Because particular proceeding has already started, Lordship, under Public Premises Act 2003, Lordship. So, cause notice was issued, Lordship, and reply has been filed, Lordship. And decision is yet to be taken by the competent authority. That's the state official, Lordship. Before that decision is taken, Lordship, how, Lordship, this petition can be filed, Lordship? Because Honorable Supreme Court is very clear, Lordship. There cannot be a writ against the Lordship, so cause notice. You have been given opportunity to place your case, Lordship. And You have already placed, and it's for authority to
You have filed reply.
Yes,
reply file.
your lordship, my case is
Now it's
different.
for the authority to decide, lordship, because section 5 says of this act, lordship. After lordship, this so cause has been reply has been received, lordship. The authority will consider that, lordship, and appropriate order will be passed. Either lordship accepting the lordship case of the or by rejecting order. Once it's rejected, lordship, then appellate forum is there, lordship. Without exhausting all these provisions, lordship, it cannot be filed, lordship.
Okay, we'll issue notice.
Your lordship, here one point I would like to
And
respond.
here, lordship, I'll
Give you a short date. I'll give you-
Your lordship, my point is that, your lordship, I'm not saying that proceeding can, but I'm against the proceeding itself, because whatever the learned,
that cannot be, lordship.
Notice. That's issuing notice.
because we are at the verge of eviction, your lordship. They are before taking decision.
As soon as-
No order has been passed, lordship.
They can
At least
submitted your
at le-
reply. Come on. You have
uh,
submitted your reply.
I have,
Issue notice.
uh,
I'll give you a very short date.
at least coercive action may not be taken against me, at least till the next day, till the next day, because
It is not maintainable, lordship. It's liable to be dismissed, other lordship.
No, it is done. We'll issue notice. Short date?
thought that
Yes. I'll
it
give you-
may turn infructuous, your lordship.
No, it won't become infructuous. You have given your reply, they will decide, and then you.
My reply was in the form of the challenging that proceeding only, because no proceeding, because my application is under consideration. At that time, can I be treated as an unauthorized occupant and a proceeding can be initiated under
No, no.
that particular act? Because four of the other persons have been allotted with the allotment, land allotment, and we are being treated like unauthorized occupant.
Merits now. I cannot go into the merits. How they have been allotted the land, in what manner, what is, I cannot go into the evidence now.
At least
If you are not an unauthorized occupant, then they won't ask you to vacate. They won't evict you.
initiating
Unauthorized.
eviction proceeding, your lordship. Prima facie, they are initiating eviction proceeding against me.
You have given a reply.
I have given a reply. Now they are even now
I'll give you a short date. I'll give you, you have given.
at least coercive action for till next date, your lordship, till next date. At least I may be assured that till next date nothing will happen. Thereafter it may be discontinued. I do not have anything to say.
Once.
But till next date, because once
That will continue.
It will always continue.
So,
till next date, your lordship, my case is that discriminatory
I know, I have. gotten-
discrimination has been done prima facie, because at page 38 I have already.
So you are given to occupy a place and you are establishing your business, and suddenly if you are evicted, then you will suffer. I understand. I have dealt with all.
And that too during the pendency of my application. Why my application is not considered? Because this honorable, what I am requesting, what I am requesting before this honorable court, that I have a right under section 12 of.
Petition, this order cannot be passed. Otherwise, I would not hesitate to pass any such order. I have passed, you have been watching me throughout the day. I have passed interim order. Here I am not willing to, in this case. In some of the cases, not all.
2 weeks. No?
Hmm?
2 weeks.
2 weeks, yes. I'll give you a date.
At least my application, my written objection may be considered. Before that, they do not do anything against me. That is at least that much of protection. Because if I have given.
Pass through this written WPC, I cannot pass such an interim order. We will hear both sides and then we will continue, then you.
Because if once,
You can also obtain-
if the other side is saying that if I have filed my written objection, then estate officer has to consider it. But before considering, let no coercive action be taken against me. Let that proceeding.
Cannot come and stay all the matter to the petition. Learned Counsel Mr. N. Sharma
Yes, Your Lordship.
is present for the petitioner. Learned Government Advocate, Senior Government Advocate, Mr. A. R. Tapim.
Yes, Tapim.
Yes, Tapim. Senator Long, give me a day after 2 weeks. Or a week, after 1 week.
That may be.
After 1 week. Vote 12
No issue.
on 4/12. Extra copies.
Oh, bless you.
Item number 12.
Fair play to you, Lordship. Madam, in this matter, madam, we are praying for setting aside of this impugned suspension order. Madam, it is covered by Ajay Kumar Chaudhary. So I will just go through relevant page. Page 17 is a impugned suspension. Page 17 is impugned suspension. This was passed on 20 August 2024. After this, he was in suspension and then he filed one application for the revocation of suspension saying that the suspension has not been extended. So that my application is in page 47.
Suspension has not been extended.
Yes.
3 months.
Yes, it has to be extended. Yes. So my application is page 47. So I will just read the prayer portion of this application. It's in page 48.
Yes.
Page 48, yes, may I read? The statutory period of 90 days, which commences on 28/2024 date of suspension, has already expired on 20/11/2024, and the suspension has not yet been reviewed. Moreover, I have been not been charged. So this was application saying that his suspension should be revoked because his suspension has not.
Please, Chancellor, what is your prayer?
My prayer is that the suspension is not been extended under the statutory provision, section 10 or section CCS rules, section 10 clause 6 and 7.
Every 3 months it has to be extended.
It has to be extended.
So we cannot decide like this. We will have to hear the other side also.
Yes, here's a department. So even they have filed the reply saying that he has not been extended. So I will just take to their affidavit also.
In fact, Lordship, I'm appearing on behalf of Standing Council Education. In fact, last occasion, the respondent department was directed to bring on record the status of the suspension.
Yes.
We have filed a status report saying the suspension has not been reviewed. That is the status.
So on that ground, my lord, Ajay Kumar Chaudhary in this judgment also, if the suspension is not reviewed after 90 days, then the suspension is can be revoked. Can be.
To hear.
Yes.
It is in the rules also. Even
Yeah, the rule. I will just read.
our rules also, it is there. In the state rules also, it is there. So it has to be extended. Every 90 days it.
Yes, that's what I will just
But
read.
if it is not extended, then it has to be revoked. That is, we'll have to decide the merits of the case.
Yes. So I will just read their affidavits. As per the affidavit, they have already said that they have not reviewed the suspension. So I will just read that paragraph 2 of their counter affidavit.
You are for which respondents?
Education departments, all the respondents.
Required. Actually not required. So
So-
shall I allow to pray?
As per instruction, the Standing Council has instructed me that Lordship may decide because based on the record that we have brought in. Because since the suspension has not been reviewed, therefore.
Then give me the rules and everything. You see, there are rules and then there are certain conditions. Just the entire rules, I will require the entire rules. They are just from another state.
Yes.
So here.
State, we don't have separate rules. Our state is covered by the CCA and CCS rules, 1965. So 1965, section 10(6), I will just read section 10(6) and section 10(7) is very clear. If the suspension is not extended, then it has to be revoked. I'll just read the section 10 subclause 6.
Where is your affidavit?
Is in it's in the record. It starts from page 51.
I think they have applied the CCS, I will. relevant CCS. Page 50,
51. No, we have just brought on record the status
only the state.
furnished by the department.
It's in the paragraph 2, my lord, Your Lordship. Paragraph 2,
51.
52 is the page.
Okay, 52 is the page.
Yes, second paragraph.
Second paragraph.
Yes.
Yes, please read.
Yes, the answering the respondent back to state that the review of the suspension order dated 20/08/2024 issued by respondent number 2, while suspension order such and such has not been reviewed and as on date. However, the subsistence allowance is being paid to the petitioner as per CCA Rule 1965. The department proceeding against the present petitioner is going on and so on date. No final decision has been taken by the discipline authority in this regard. Yes.
Department proceeding is going on, no? No. Department proceeding is going on. I think it was an error on their part that they have not reviewed the suspension order. We'll need a hearing. Department proceeding is going on.
I think
We'll need a hearing. See, it was error on their part. It happens in offices, they forget to review and then they forget to extend. And then then they try to take the benefit. But again, definitely, if it is not extended, they
my lord, ask.
benefit. But the proceeding is going
Well,
on.
I will just.
Proceeding has not been closed.
I'm not, my lord, I agree to your lordship point. But then suspension proceeding, my lord, I will just relevant paragraph of Ajay Kumar Chaudhary.
You,
Yes.
this will go against you. If you insist, this will go against you because the proceeding is going on, suspension.
Yes.
This will go against you. We will rely on Ajay Kumar Chaudhary, we will rely on judgments. I am also privy to all these type of proceedings.
Right.
I was the head of the DPC.
Okay.
Always heading the DPC. So when suspension is always still there, the suspension is not revoked. Who will revoke the suspension? Not through writ petition. We'll have some send a direction there.
But then, my lord, as per the CCS, because they are also governed by the CCS and CCA rule, it clearly says that, my lord,
Give them a direction to proceed according to law. Why? Why do you want such a direction?
my lord,
I cannot revoke the suspension order. I can give them a direction to proceed according to law. Why do you want such a direction?
no, in fact, my prayer is that the suspension should be revoked because when the CCS rule says that when it is not extended, it should be.
Okay, I am taking your prayer. Then I have to hear from the other side. If they ask me to pass such an order, then I'll pass an order.
My lord, I think.
May I pray that since I'm representing the standing council, let the matter be fixed after 1 week.
Let it be fixed after 1 week because you see, he's not aware of this case. Maybe he's. I don't think he has got the brief with him. I can pass an order if he agrees. If there is no objection from his side, I can pass an order. I can direct to pass some, but I cannot revoke to this writ petition. Direction has to be given to the DPC.
Yes, yes, yeah, that's true.
We'll fix it for another date.
Then no issue, your lordship.
Otherwise, you'll not get the relief you're seeking. You may not get. Only one short date.
Yes,
And
yes.
you're lucky also, you're getting the pension,
Yes,
provisional, what is it called?
subsistence allowance.
Subsistence allowance.
yes.
And then they have not reviewed also. That way you are on the better side.
Mhm, yes,
on
yes.
the gaining side. So we'll face a short date.
All right, sure.
Learned Council, Mr. Item number 12, no? S. Mo
Yes.
is present for the petitioner. Learned Council, Mr.
R. Koyu.
R. Kohli.
Koyu.
Koyu is present on behalf of Learned Standing Council, Mr. T. Tagum.
Yes.
And has prayed for adjournment. Okay. Okay. You have prayed for adjournment. You are not submitting anything.
All right.
List this matter after, list this matter. on-
But date may be fixed, Your Lordship. Yes,
Then 27/11.
27. Obliged.
I'll take a break for 5 minutes.
You'd like to have?
We have 2 matters, no?
We have 1, 2, 3, 4, 5 matters.
5 minutes. I'll
Yes.
take a break for 5 minutes. Call somebody.
Okay.
Only for 5 minutes. Because I'll go. just
No,
to
he
my-
will.
It's very difficult to find it, you know, court is huge. Yes,
Matter may be adjourned, Lordship.
okay,
Because service awaited, I have checked the
okay. Adjourn, Learned Council, Mr. T. Tapak is present. And has prayed for adjournment with the consent of the other
after
side.
4 weeks.
Prayer is allowed, release the matter after 4 weeks.
4 weeks.
Item number 15.
Your Lordship, here I'm for the petitioner. We have to file rejoinder. So for that, we need some more time.
What is your name?
M. Khambo.
M.
Khambo. On behalf of Mr. R. Sonar.
Okay, it is submitted on behalf of Learned Council, Mr. R. Sonar, that the petitioners will file a rejoinder
Hmm.
against the counter affidavit.
Kindly, maybe it's up 3 weeks.
Release the matter after 3 weeks.
Yes.
Obliged.
Item number 18.
Yes, 18.
Your Lordship, as per the last order, the Justice Service in respect of respondent number 6 to 12 is completed. And today I have filed affidavit to bring on record.
Okay. Learned Council, Mr.
J. Karbak.
J. Tarbang.
Karbak.
J. Karbak. Karbak. Item number given?
18.
18. He is present for the
Petitioner.
Karbak is present for the petitioner and has submitted that an affidavit has been filed relating to service of notice on respondent number 6 to 12.
6 to 12.
It is submitted through the, it is stated through the affidavit that I cannot find the affidavit. Record, no? 17 to 11. Page 18. Till date, no affidavit has been filed regarding, but they have stated the same file. The affidavit is not on record. It's not on record.
Okay, I have filed it this morning.
This morning.
Yes.
Registered to place the affidavit on record.
Recorded.
Okay, we have it. Just delete it. The affidavit is not on record. See in the affidavit. Placing on record the service of notice to respondent number 6 to 12. Which clearly reflects that the respondent number 6 has personally received the dusty notice, comma, respondent number 7, 6, 7 have personally received the dusty notice, comma, respondent number 8 also have 8, 9 also 10, 11 and 12 all have
All.
received the notices on routed through dusty service. Learned Council,
Your Lordship,
Miss,
I'm appearing for 1 to 5, Your Lordship. Government advocate.
Learned Government Advocate Miss T. Wango, no?
No, P. Sangeeta.
P. Sangia.
P. Sangeeta.
P. Sangeeta is present for respondent number
1 to 5. Your Lordship.
1 to
Official,
5.
yes.
Okay.
Your
You
Lordship,
will list
we,
for admission?
Your Lordship, we are yet to receive the extra copies, Your Lordship, that have
Okay, extra copies to be furnished to respondent number 1 to
5.
5.
Fine.
The notices issued to respondent number 6 to 12 is deemed to be served.
Yeah.
Then list this matter after 1 week there.
1 week.
It will come for orders and then we will proceed for admission.
Okay,
Okay.
much obliged.
Item number 20.
Did you call Sunil now? Yes, yes. Let me see if I can pass any order.
Okay, but his number is very busy.
Okay, and that other one?
I could not call because I was trying his number. His number was busy. Should I?
Time. Before rising, you can try. If they won't turn up, then let me see, try and see if you can pass any order. It's plausible.
Lordship, I have not received extra copies yet, Your Lordship.
Learned Council, Mr.
M. Bagra, on behalf of Subbu Koyang, sir. Your Honor, as per the direct M. Bagra.
Bagra is present on behalf of Learned Council, Mr. S. Koyum, Government Advocate, Ms. P. Pangsu.
R. Basar.
R. Basar, okay.
My lord, I just
Sir is present and the submitted that they have not received extra copies. Who stop petitioners to furnish extra copies is
my lord, my one submission there. Regarding this matter, the Senate Council instructed me that the part of the filing during time, they only make one copy only. So during the meantime, tomorrow myself, I give the extra 4 copies regarding this respondent 1 to 4. And regarding the respondent number 5, the service already taken up, but they still awaited regarding the returnable notice or whatever it is. So as per the
Basar is present for respondent number 1 to 4, no?
Hmm.
Government Advocate, no?
Yes, Lordship.
Service service report on respondent number 5 is awaited.
awaited.
This after when?
4 weeks, Your Lordship.
4 weeks.
And my senior counsel direction me that 1 week, whatever the
Lordship, I have not received extra copies yet. I have to communicate. 1 week will not be enough.
Okay, let's take a midway. 2 weeks.
No, 2 weeks. I have to get the extra copies, Your Lordship, and I have to communicate to all the all the state respondents. Yes. And after that, they will prepare and.
State, you know.
Yeah.
Okay, my
3
lord.
weeks there?
4 weeks, Your Lordship. 4 weeks. Obliged, Your Lord.
Much obliged.
Item number 21.
Yes, my lord. I am the petitioner, my lord, regarding this matter. So, my lord, before come to the point, my lord, I just highlighting some history of the case, Your Honor, so that it's clarity regarding the matter, whether the interim prayer is allowed or not, my lord. First of all, my lord, may I come in the page number, Annexure 1,
Connection 1.
no, Annexure 2, page number 18, my lord. This is a impugn order regarding the some village 1-8, my lord, connection number 2.
Okay.
This is a order passed by the village authority, and then after subsequently the executive magistrate finalized the order dated. There is a land, the community land, Hemu Hedu community land. This directly indirectly connected to the Pumbang Yerlung to Bose Sokang, belongs to the both the brothers clan, Hemi and Hedu clan. Both are the same family members. And after subsequently what happened, my lord, during this year also, there is some compensation sanction is passed by the government of Arunachal Pradesh. It is the district of the Siyomi. And subsequently what happened, my lord, both the clan brothers, due to some dispute arise, both the brothers jointly not give the submission, resolution regarding the compensation equally and whatever it is. Then subsequently the clan brother, Hemu clan, that the petitioner of this case, filed the one application regarding the complaint that the other clan brother is not collaborate with us to filing the joint resolution regarding the compensation. So apart from this, you may divide it the equal share or whatever the square meter as per the square meters, they may be allocated for the land compensation. So after heard this application, then after on 13/6/2024, Annexure 4, my lord, page number 21, the concerned Deputy Commissioner of CEOME issue a notice regarding some hearing between the clan brothers. And subsequently, my lord, on 8/7/2025, before heard of this case, the petitioner directly served the application to collector of CEOME, that is Deputy Commissioner, and LRSO regarding the proper grievances and entire episode of the case. Already, day 1 until date, Your Honor. After receiving of this application, everything well known by the concerned respondents, Deputy Commissioner and also. Then it's very sad and sorrow, my lord. In Annexure 6, the concerned Deputy Commissioner passed an impugn order on 8/7/2025 without any single consideration regarding 25 Annexure 6, my lord.
So this is the impugned order.
Impugn order, my lord. So after took the consideration regarding the both the parties' submission, they conclude that there is a dispute between the two clan brothers. So only they pass the few type of the compensation allowances, like except the plot of land disputed from Pumbang Yerlung to Taking Lengtak, remaining trees, house, agriculture, whatever properties may should be dispersed the compensation amount. But whatever the any settlement, amicable settlement between the party appropriate forum, till then no property plot of land regarding compensation allowed. This is the impugn order, my lord. First of all, my lord, for this regarding what happened, my lord, the 8/7/2025 was the application I filed before the Deputy Commissioner regarding the every fact and circumstances that how come that this plot of land acquired by both the person, clan brother. Then after the concerned authority, executive magistrate passed this land is properly, directly, indirectly possessed and honored by both the clan brothers. And subsequently, what happened, my lord, because of some immaturity without teamwork of both the clan brothers, some dispute arises. So subsequently, they ally part of the compensation. So main concern is that, my lord, the stretch road, Pumbang Yerlung to Taking Lengtak, it's directly, indirectly go to the road only, not the tree and the house. And what happened, my lord, the presently the petitioner, family member, so many houses there, the residing there, Pumbang Yerlung to Taking Lengtak places. And the concerned authority every time give a threatening. They collected the bulldozers, JCB, Pockline, all the police force and IRB force, and give it threatening and life threatening, as well as the always try to destroy their houses, their properties, and they to their life also. They each and every day fear and very tense atmosphere because it's created by the respondent side, Deputy Commissioner and the also, Your Honor. For that purpose, Your Honor, we filed the one WPC 317/25 in page number 26. So due to some clerical error in the petitioner side, we withdraw the same and file a fresh this WPC, my lord. Page number 26 to 27. So subsequently, my lord, on page number 28, Annexure 8 Coli, this is a prior review and modification order, impugn order 8/7/2025. In here also, my lord, we clearly mentioned that how come this land is came up, what is the actually dispute arising between the parties, and what the impugn order passed without consideration any single genuine ground of the petitioner side. So subsequently this happened, my lord. We just grievances that we never ever question arising regarding the development purpose. Any other purpose of the like the other parties, any rights and equality. But we need that whatever we have a possession of the land, which our generation to generation as per the second annexures, which clearly mentioned that we are also one of the owner of the plot of land, my lord. So this genuine ground, Your Honor, the concerned authority each and every day give a threatening. All the equipments, heavy machineries, just for a timing till the other respondent not came up. Respondent number 3, that is the Heduk line. Till then, madam, this interim order not been in upon the petitioner, my lord, because they give it threatening, give it so many troubles to the petitioner.
What type of order do you want? Interim order?
This order not in the not to do any illegal act upon the petitioner, my lord, because they residing their place also very tough to survive, my lord. They give so many threatening. They every time we come to the warning that today itself we will not vacate the home, then we totally destroy your home and whatever the properties you have. The children, the wives, the sisters, they all. Deputy Commissioner, respondent parties, Your Honor. Respondent 1 and 2, Your Honor. So we are very fear that each and every day, my lord.
You say something?
Your Lordship, today it was listed because the steps was not completed in the last occasion. Because private parties, they were implemented, they were added in the last order, dated
7.
Yes, for implement, I was filed for implement on 7th only, Your Lordship. Steps, yes, other clan, Hedu clan, because they are necessary party here. Yes, from the start only, we have been saying that they are the necessary party, and there was a order also from this court that they should be implemented. But that was not done, Your Lordship. It was done only on 7th, Your Lordship, and the steps are not complete yet. Without hearing them also, because this property, this land, particular land, this land is also, this land, yes, this land belongs to Hedu clan also and Hemi, the petitioners, Your Lordship. So they are the necessary parties.
My lord, my main grievance is
And this
that
impugned order also, by this impugned order, Your Lordship, it was suggested that, may I, Your Lordship, the impugned order is 25, page 25, annexure 6, Your Lordship, yes. Annexure 6, Your Lordship, page 25. After hearing the matter, that means both the parties were heard. The last second paragraph, Your Lordship, after hearing the matter at length, the payment of compensation against all the properties like house horticulture items, etc., standing in the proposed stretch from Pumbum Yorlong to Taking Lingtak should be released without further delay. The payment of land compensation against the stretch from Pumbum Yorlong to Taking Lingtak is hereby kept at halt till the title of the land is amicably settled at the appropriate forum. It's a civil dispute, actually, Your Lordship. They should knock the door of appropriate forum.
Okay, no interim order.
my lord,
Interim order, there is no clear interim prayer also, Your Lordship.
my,
It is
my
very
lord,
vague.
may kindly the petition, Your Honor, page number,
Where is the prayer?
in my petition, my lord.
But without presence of private respondent, Your Lordship, it is not possible.
Prayer, my lord, page number 11.
They have to be heard.
After hearing both the sides and maybe arriving at a settlement also, you never know.
My lord, the main thing is that the private respondent not create anything. The creating
They
thing,
should have been made party, Your Lordship, from the start, Your Lordship. They should have been made.
No,
but my lord, regarding to this matter, my lord, we do our best regarding whatever the
Case for another date. I am not giving interim order here. Passing interim order.
And
It's for next Monday then. You convince the other bench. I'm not passing interim order.
my lord, the main thing is that the respondent have a superpower regarding the police force, airman force. They give a training and all the mercenaries.
Allegation is this. We don't
See, DC will do his duty. How can this court issue a restraint order against the DC?
But my lord, regarding if
No. You want a date, I can give you a date, but I'm not passing any interim order. Should I issue notice or I'll give you a date?
ma'am, notice already served, but still awaited regarding the respondent number 3,
Okay.
private respondent.
Okay.
My lord, thing is that my lord, they don't finger any single penny to us. And apart from the single penny, they illegally encroach us in our plot of land and seize our the plot of land along with the houses. And we are vacated from the any time, anywhere. So we are very scared life, Your Honor. Because private respondent never do anything regarding illegal act. But the respondent number 1 and 2 is do so many things for us. So it's very tough to live each and every life. Not a sleep life, Your Honor.
So sorry, see, since 5/9/2025, nobody has passed an interim order. You try your luck before the other bench. I'll pass an order.
But
Okay.
at least
Heard learned counsel, Mr. No. Heard learned counsel, Mr.
M. Bagra.
M.
Bagra.
M. Bagra for the petitioner. Learned government advocate, Ms. Sangeeta or
P. Sangeeta.
P. Sangeeta. For the respondent number, how many?
1 and 2.
1 and 2. Notices have been issued to the other respondents. Service report is awaited. List the matter on. Give me a date if you want to know.
Your Honor, main thing is that the private respondent come whatever a time, but without any interim order, the respondent anytime do anything, Your Honor. We are very risk life. If they at least give me some interim protection to save the life, Your Honor.
No. Not now. After hearing the parties, we can pass an interim order. If you want a date, while I am there, then I can give you a date then. But the other side, I have to hear the other side. So I'm not here next week. So when we will be able to, notices are also to be served.
Yes, it is still awaited.
Give 1-2 weeks date. You want a date or 2 weeks?
You know, no, actually my main concern is only the interim prayer. main case, it's okay, Your Honor. We waited for some time, but
Convince so many benches who are in session of this matter since 5/9/2005. Nobody has passed an interim order.
because we not pray regarding the on-date point of time, we just go for the notice.
17th of December, yes, 17th of December, if he is.
December of this year. Because he's also suffering.
So much, Your Honor, because they have not suffered anything, the respondent parties.
8/12.
8 December.
Your Honor, if within this month, my lord, if possible.
And within this month is 27.
27?
Okay.
27, my lord, if possible, 26, 26, 25.
Yes, 26.
27, 26, I'm not available. I have some
27, I'm out of station. If 28,
28. can-
Yes, 28 November. Yes. Yes,
Item 12.
he is not here. Otherwise, I would have tried
Okay.
once more to give some relief, but he is not here.
He left.
He's already left. No.
much of it.